What are you guys seeing? Is it me or is it a timer? Can you see me? Levi? Levi. Hey, Levi. I don't know. I tried to do that. Thank you. Okay. I tried to stick a timer in there, but I guess it doesn't really work. Not for me anyway. I'll figure it out over time. So how are you guys? So what's up? Anybody have anything they want to start off with a bang with? And I also wanted to ask you, did you guys see anything? I don't know. I want to call it fake news. It is complete clickbait saying that there's going to be like a 30% reduction in Social Security benefits to recipients. Anybody see that? Hi, Salvatore. Salvatore, Emma. Is that two of you? Nice to see you. Tristan, nice to see you. Justin, hello. Hi, Lesby Rockin'. How are you? Anyway, so let me know. That is something that I was seeing, and I have a bit of a rant about it. Some people are saying, so if you see this, just take it with a grain because it's false. They are saying if seniors and disableds have their taxation on their Social Security benefits eliminated, so they don't have to pay the taxes on those benefits that they, let's face it, already paid them when they worked to earn and pay for that insurance, that it will cause them all, and all of you, whoever's on it, to suffer likely a 30 or 33% cut in their benefits, which makes no sense, guys, because Social Security is not funded by our income tax. It's a totally different tax. So it is fake news. It is clickbait. It is all sorts of crap. Hi, Christina. So that's been a big part of my morning, actually, disputing the fakeness of that. But anyway, what do we have here? We have George. Hi, George. Will there be CDRs with SSA employee shortages? Yes, they were stopped for a few months over the summer, George, because the SSA was trying to divert existing probably DDS employees over to, from CDRs, DDS employees from CDRs to help them work on the backload for people on initial and reconsideration. That ended a few months ago so that CDRs could continue. But they are short staffed. So I still think there's probably going to be late ones. I mean, everyone's always going to have CDRs. They've been around since, I shouldn't say since the beginning of the Social Security disability addition to the SS program, but for a very long time, longer than I've been doing this. And that's couple decades. I shouldn't say a couple decades. I'm not that old yet. So anyway, yeah. CDRs are slow and they're a little backwards at times, but they will continue. And honestly, that's a good thing. You really don't want, we did that Friday fraud law review, and it's usually always someone scamming the SS system. And we don't really want that, right? I don't know can you hear those dogs barking in the background, guys? I'm wondering how much the sound filtering works here. Saw that SS, okay, this is Salvatore, Emma. Okay, saw that SS will be reduced in 2034 to 2036. I don't think they say it's going to be reduced. I think what they say is that is about the time frame that it will no longer be able to pay the full amount unless they do something in interim, like jack up our taxes, meaning that the Social Security FICA tax, not the income tax, which would not affect that, or something terrible, I think, would be making us be older to get retirement. I think it's hard enough to get to 62 for the crappy little early retirement, that it will be, if you extend either that or full retirement, they already moved it from 65 to 67. And I think that's hard. Hi, Deb. Deb Lindley. Hey, girl. You too. So the 34 to 36, and I didn't look at it recently, but just so you know, that number for the SSD fund was 2065 at the beginning of 2020. right before COVID hit, comes the report, the spring report for the fiscal year prior. So every year during those prior years there, well, the last few prior years, it was climbing and climbing. And it got to 2065. And then COVID came upon us and helped destroy that, because remember, people were out of the workforce during COVID. A bit long in the tooth, I think, for that. But nonetheless, the only way the social 85% of the fund, if not more, excuse me, guys, is funded from our work. Those of us that work, whether we're disabled and work, we work part-time, we work full-time, whatever, the disabled or disabled, doesn't matter. Our work income is where the Social Security FICA taxes come from to support the almost the complete Social Security fund. No other taxes. So when we take people out of the workforce, or we encourage people not to work or to be dependent, we cut that off at the knees. And that's what happened. So it shrunk back. Now, 2034, 2036 is not as bad as it used to be. If you look at the reports back in the early teens of the 21st century, we were looking at like around, and I might mix up at 1 year, be off a year here, guys, but 2014, 15, we were sinking in 2016. That's how bad a job they were doing back then. I mean, it was horrible. And, you know, people were really, really panicked, understandably so. And then they did a few different things to try to shore it up, including taking away a big chunk of spousal retirement benefits. I don't know if you guys remember that, in that law that was passed, bipartisan, by Congress, signed off by President Obama, to get rid of a portion of the spousal retirement benefits. The only problem I had with that in general is that they didn't give the people that were about to retire, those spouses and those families, ample notice. I don't think they should have hit people that were soon to be 62, like that year. I think they should have maybe cut it off 10 years earlier, maybe 52, maybe 55, like only make it affect the younger people, of which I would have been one, not now, but I would have been, because we have time to maybe make up for it. Because I think if I remember, it was something like $60,000 on average was what was affected for people for whom it would affect, which would be spouses. All right. I hope I got to the question. I know I deviated a little bit there. I'm just scrolling up, making sure I didn't miss anybody. I like to go first in, first out, guys, for those that get here timely. I appreciate it. This is Terry. Hi, Terry Clemens. Is it a good thing or a bad thing if the appeals council remands my case to another ALJ on my first remand hearing when the old ALJ is still working there? Interesting, Terry. I don't know the answer, but just to get everybody else up to speed, normally if you appeal an ALJ denial and you're appealing it to the appeals council, right? That's the next step. If you get a remand, it goes back generally, and I've never had it contrary to this, except once when my ALJ passed away, sent back to the same ALJ for that ALJ to correct whatever error they committed so that they could remake a decision, which could be the same decision in the end or something different, but they just have to follow what the AC says they did not do. The fact that they sent yours, Terry, to a different ALJ, while your ALJ is still working there, I don't know. Maybe, I don't know. I honestly don't know the answer because I've never heard that happening before. So it seems to me that ALJ might be in a little bit of hot water. I don't think it would be on your case alone, unless there's something really wonky going on in there. And of course, I know nothing about your case, but maybe maybe he's getting a spanking. Maybe it's something he's been doing with a lot of cases. I don't know. I did have an ALJ once that awarded me on a case I did not expect to be awarded. It was a younger person. I took it because I knew the person was disabled, despite the fact that it was going to be a very, very uphill battle. And God bless her, she was very contra to her doctors, so they weren't exactly in favor of her generally, because she was very repudiating of medical advice and stuff like that. I don't even know that she was wrong, but you know, you got doctors on the other end who have egos, and when you try to propose something different, some of them don't take it too lightly. So this judge shocked us when he had one hypothetical that produced no jobs. I was in shock when I was listening to it, and we knew we won. Well, not so fast. There was something obviously going on that we got scheduled for another hearing. I remember saying to the person who called me about rescheduling a hearing, I go, "We had our hearing. It went great. What are you doing? Stop," you know? And she's like, "Oh no, yeah. So there's going to be other ones. They're all getting redone." So I think maybe that ALJ might have gotten the old spanking for maybe he was awarding everybody. And, you know, I think that makes big red flags to the SSA. And I don't know. So that was one. We did go back to hearing with a different judge. And our judge hadn't passed away, but I guess he was maybe given blanket awards. How sweet is that? But I was shocked, to be honest with you. I didn't think would, but we went back to a different judge, and lo and behold, we won. Still a younger person. So I don't really understand it. You know, sometimes there's no rhyme or reason, but you have to really love the ones that work out well, because I did know for a fact that she was disabled. It's just that her evidence was weak. And technically I couldn't have been complaining heavily if there was a denial. Okay. Terry, I gave you more than you asked for. Sorry about that. I tend to do that. Okay. Christina, hi again, honey. Terry's saying that the old ALJ had a 35% percentage rate, I'm guessing, of awards, Terry, and my new ALJ has a 47% percentage rate. That is a notable difference. I will tell you, there's a lot of judges with less than 35. I feel like 47 is on the higher end these days. So that's nice. So good for you. I will keep my fingers crossed for you. Oh, Tristan, you heard the dogs? Were they really loud to you guys? I mean, I can go back and listen. You know, it's in the beginning. I don't tend to listen to the whole thing. That would be a little. No, Christina, just a little. Okay. Rockin'. We can hear you over the doggos. Thank goodness. I have a pretty loud voice, I have to say. Yeah, Deb, they have a hiring freeze at the SSA. That's been going on for a long time, guys. That's nothing new. I believe it will continue for now until they figure out, you know, where some of the pork is coming from, right? Some of the waste. Which could mean, by the way, moving people from one area that there's an excessive amount that aren't doing squat and moving them over to another area. It doesn't necessarily mean, you know, they're not going to move people around. I just think they're not going to be hiring, particularly in unnecessary places. Terry, by me having to get a cane. Oh, I usually pop those up, don't I? Sorry, guys. By me having to get a cane and a wheelchair, and I had to get a handicap parking permit. Those are actually pretty easy to get, so that wouldn't be your strong point there, Terry. I didn't have this the last hearing. Is that good? Yes, that's very good. Is the cane prescribed, Terry? Is the wheelchair prescribed? If it's not, get it prescribed, if you can, and produce that the prescription, yeah, for, you know, to the ALJ. And you know, I don't know if it's possible getting, if you have the statements in your records that say he really needs a cane, I'm going to prescribe this, or he needs a wheelchair at times, I'm going to prescribe this. That would give a little bit of, you know, rear view window durational as to how long you've needed that cane and that wheelchair. It also defeats the thing that some people, this happens to people a lot, and it's even in the SS rules. If you have a cane, guys, but it was not prescribed, it is not considered medically needy necessarily. If it's prescribed, it's supposed to be considered medically needy because a doctor that's treating you prescribed it. So If you can get it prescribed, please do. Oh, thanks, George. Super sweet. Trimmed brisket. Thank you. Smash that like button. You're super nice. This is Dwayne Price. Hi, Dwayne. I lost my mother recently. I am really sorry, Dwayne. My husband just lost his mom recently, too. Do you have to request a death benefit? If so, how? If you are eligible for a death benefit, Dwayne, which is a whopping $255 and has not had COLA in the entire 2 decades I've been practicing this, and I think probably a couple decades before that. The death benefit is kind of a joke. I don't know that's going to help anyone's funeral, but if you're referring to survivor benefits, because there might be a dependent that might be eligible for a survivor benefit, yeah. For both of those things, you're going to want to contact the SSA and see what you're eligible for, or any of your loved ones, really, that might have some sort of dependency connection to your mom, in the legal sense, of course. Tristan, yeah. It would be nice if they increase Social Security by 30%, definitely not decrease. I hear you. And while I have a pretty good grasp on the numbers, the COLA that is supposed to keep our Social Security benefits in line with the cost of living doesn't do that. And I think that's because the COLA that they use, and there's probably not a better one though at this point, but they could make a better one, a more accurate one. I don't think it increases our benefits percentage-wise for the year to the same degree that the inflation went up, particularly when we have high years of inflation, of course. So yeah, I don't feel like Social Security pulls the weight it used to in terms of getting people to survive. Now, of course, sometimes people are living in very high and expensive places and expect themselves to get a higher amount than the guy living in a remote area where it's a cheaper cost of living, where I plan on living when I retire. Because, well, I live in Bel Air. They should be giving me more money so I can afford my lifestyle. Not so much. I don't know. Not so much. That is where for SSI folks, the states contribute their little extra amount. If you get SSI, you get some extra from most of the states. I don't think it's all, but most. But SSD is a different thing because it's the insurance you paid in for. It's not how much you like to spend it or where you like to spend it at. What you paid in is what you get out. But going back to your 30% decrease, I don't know if you were here, Tristan, what I mentioned in the beginning, the scam clickbait message going around the internet. I even saw it on CNN, and I'm not kidding, that if they stop taxing disabled people with their disability, which is an income tax, right? That's the only thing you're taxed on your Social Security benefits. You don't get taxed for Social Security on that. That they will then have to take away 30% of your benefits to pay for it. Considering that your income taxes do not go towards Social Security benefits, I hardly think eliminating them is going to affect the Social Security fund. It's not. But, that's not how you put fear in people. So they're not going to tell you that. In fact, they're saying the exact opposite. And it's for a reason. So you can surmise what it is. George Graham, no, I wouldn't. Would you ever consider being an ALJ? I would not. That would have me so stressed, I'd probably be sick. I think it's got to be a very tough job. I give great kudos to those that can do it, who do it largely correctly. I mean, nobody's perfect, but I would never. I like what I do. I like being on the side of all I do is help people, my clients. I used to do other areas of law, by the way, and this is probably why I love this so much. I did divorce law. First 5 years of practice, I was doing, I started out with insurance defense, which was litigation. I was trying a case within 4 weeks for my firm, who's got all the cases from some of the big, car insurance companies and some premise liability falls and stuff like that. But that wouldn't have been so bad. It just wasn't really a place where you got a lot of mentoring and you're thrown in baptism by fire, which was great in the sense that I got a lot of trial experience. So when I went on my own, I could, walk into court and hold my own. But when I went solo, I took in other areas like divorces and such, and that was a nightmare. Yeah, it's not, to help your own client, you have to be kind of sticking it to somebody else. And that's just against my grain. I just don't like it. So I stick to this. This is great. So no, I would never consider being an ALJ. I'm glad we have them. Can you imagine if we had to just stick with the SSA decision, the administrative decisions below? That would be terrible. So although we get really disappointed when we get a denial from an ALJ, they got a tough as nails job. It's got to be crazy. I can't even fathom it. Okay, rocking. Here we go. Let me put it on. I keep forgetting. Can I work, stay under SGA and not lose SSDI? Can I work, stay under SGA and not lose SSDI? Yes, you can. I'm so confused on working and not losing SSDI. There is so much regarding ticket to work, the 9 months thing. Ticket to work is not the 9 months thing. It's something a little different. And in fact, you probably don't want to do ticket to work unless you plan on working so much that you're going to get off of SSD. So if you have great confidence in your medical impairment improvements and want to be able to get off, that's where ticket to work might help you. I'm going to try to have a video on that one of these days. I don't really get involved much with it because that's just not my clientele's need, but it is, probably worth speaking about. SSA sends me emails about it all the time, and I tend to ignore them. The 9 month thing is not ticket to work. It's trial work period. TWP, trial work period. It's a protected period where you can try to make $1 million a month, still going to keep your benefits. They can't look at the work you're doing or the income you're earning to find that you're not disabled. However, when your 9 months is over, then they can. So, and as long as you're working under SGA and you are provably still disabled and you're not flirting with going over SGA sometimes, because you will eventually lose your benefits, you can absolutely work and stay under SGA. I had someone being a little critical the other day, which is cool, saying, equating, I think my words must have been something like, be careful and mindful when you're collecting SSD to stay within the rules, versus you're putting yourself at risk. Or I'm not really sure where the mindset was going, but I was like, no, it's absolutely true. If you're careful and mindful of the rules and the parameters, you can work. There are optics, I think, to consider, like not just staying under SGA, which is a black and white rule. There are optics to consider. And I know I have some videos on that regarding, you don't pick the job to try that is contrary to your disabilities to begin with. Because generally, many of us can push through several months of a job that's killing us if we have to. And there's no rule when you're on SSD that says you have to try to do that. And in fact, trying to do that, if you go over, you got your failed work attempts, you will pop in and out of your trial work period. Then you're going to be in your EPE period. That's only 3 years. And anytime you go over SGA during those 3 years, you owe back the money they gave you that month. So, but if you know the rules and you stick with it and you do some optically smart things and don't do dumb things optically, I think it's great. I know so many people. I work with people for this cause, because working while on disability is such a good thing for probably all of them. Maybe not the ones that absolutely would die if they didn't work because their Social Security is way too low or their bills are way too high. There's a whole nother thing about budgeting down. But I see people who love their very part-time, non-painful part-time job under SGA. It brings in money to the house. They feel contributory to their family or their own bottom line. If you're on SSD, you can save. You can leave a legacy for your grandkids. There's so much you can do aside from making your own quality of life better. They make friends. They're out socializing. It can open up a whole different world. It's not for everybody, though. Not everybody can do that. I would, serious pain conditions that are painful, even when you're at rest, probably isn't going to work. Serious disabling mental health conditions, probably not going to work. Maybe some of them, but it depends on the mental health. Like if you're found disabled purely on mental health, I would be very cautious about doing this. Okay. Enough of that. Godiva, how are you? 67. Were you born in 67 like me? I'm scheduled to have a CE exam next month. My doctor offices have not received any notices from my medical reports yet. Is this normal? No. I have copies of all my medical records. Should I send to the SSA? Scheduled for your CE exam and your doctor. See, you can't see in. If you're pro se, I'm guessing you can't see in to see what the DDS has. Your doctor's office might not even know that the records are in there. Sometimes it's called a HITMER, HITMER. I forget what it stands for. But that's where the SSA already had arrangement with the big health network, not your little office per se, if your doctor's part of a health network. And they can go in and click a button. They already have your release. They got it from you in the beginning. And then they get the records in seconds. I mean, it's like automated. It's a really cool thing. So what I would probably do is call the adjudicator, the DDS, the person who is working up your case from that state agency that's outsourced to the feds, and ask her. She could even send you a list of what they have, or she can give them to you on the phone. And then you'll know which ones came in. I would kind of want to know from what date to what date did they come in, because if they got them 6 months ago, there's 6 months later, there could be more records. So like I said, I don't think you can see them in your online access at this point. If anyone knows differently, let me know, because I was under the impression that might change one day, so that pro se claimants can see everything the lawyer of a represented claimant can see, which only seems fair to me. So I don't know. I would talk to them first. And then, yes, if you have to, I would send the medical records up. You probably heard my cautions about willy-nilly sending up some ad hoc records you have in your possession when you file pro se or with a lawyer, because sometimes adjudicators are like, oh, I see Dr. Jones is in there. I don't have to order them now. Not true. They're not complete. And, they're a continuing treating doctor. They have to be ordered. And oftentimes what you send is just the documents you had, not the full 9 yards. So that's why I often hesitate. I definitely wouldn't send them to the field office. They seem to disappear. But if you talk to the adjudicator, tell her what you have, tell her that it's not even complete if it's not complete. If you've had subsequent visits, just say, but I have some of them, but can you order the rest? So maybe you're going to have to communicate with your adjudicator. That's what I would be doing with your communicator. So you just have to do it. Okay. Kevin. Hi, Kevin. Am I saying it right? Varecki? I like to try to figure out names that have slightly different spellings that I'm used to. I like your eagle in there. That's very nice. Hello. Hello to you. I applied for SSI and have doctors. Did I just say doctors? No, that's weird. Lawyers doing the work for me. Next Monday, I have to see their mental doctor. I still work, but just 20 hours a week. I have a hearing. Add to, I see what happens. So you're applying for SSI. So you're not applying for SSD, Kevin? Just SSI. And have lawyers doing the work for me. Good for you. Next Monday. And remember, without even knowing the lawyers, I think it's good for you in the sense that they have every incentive for you to win. They don't get paid if they don't. So any of their work is going to be money out of their pocket, wasted, tossed, if they don't win. So I think it's good that you have them. So hopefully they will do right by you. They have every incentive to. So you have that on your side. Next Monday, I have to see their mental doctor. Okay, that's the CE exam. You don't really have a question here. I will say, working 20 hours a week, I assume that's under SGA, or your lawyers would have told you. Just my personal optic limits, I think 20 is the outside of any part-time work. It's the high end optically for when we are in the middle of a disability claim. You start getting over that, they start to maybe give a adjudicator a unspoken niggling of the brain that says, look at all that work. You know, I see two 8-hour days in there. You know, 8, that's 16 plus another half day. Maybe they could do, you know, 4 8-hour days instead of 2.5. And that's practically full time, right? All right. So just keep that in mind. Don't try to, some people are like, I'm only working 30 hours a week. And I'm like, cut that out. Thank you, Christina. Let's see what we got. All right. Zara says this. I will say, she says she's disabled, or Zara, I think it's a she, but I don't know for sure. So no offense. I'm disabled vet. Thank you for your service. Zara, thank you very much for your service. With anxiety, depression, PTSD, hypertension, herniated disc, radiculopathy. I'm 49 and go before ALJ in March. I'm also, yeah, okay. What are your odds? There's no odds book, really. It really depends on your medical records, Zara. I'm curious, 49, are you a couple months away from, when is your 50th birthday? Sometimes the ALJ can give you the benefit of being 50 when we're like 49 in 2 months or thereabouts. So then you could at least, you won't have back benefits, but you could prevail. And that's really the most important thing, right? Prevailing earlier than that, it's difficult. But again, depending on herniated disc, does it squeeze your spinal cord? Does it pinch nerves that are exiting? Nerve roots? So I really can't say. Under 50, as you all know, it's a far harder burden. And that's true of vets as well. So, all right. Good afternoon, KSI Clee. Okay, DJ. Do I need to tell the SSA if I sell my house or purchase a new one? No. Unless you are on SSI. Because they're going to change your finances. Remember, SSI, we have to have, you know, a certain financial picture. Now, if you move, you do, because they need to know where to reach you. So, yeah, if you move, tell them. Or if you're on SSI, that's pretty much what I would suggest. Where are we at? Terry Clemens. Yeah. That's not really a question, so I'm going to move on. All right, Terry? KSI. I just got approved on my initial application. Yay. Yay is right. Good for you. See, guys, it does happen. But you do have to have that evidence ready to go. And sometimes that means wait on applying, maybe get a protected filing date, and get your evidence building all lined up. Oh, Terry. So you're saying that, just another item by Terry. I do have 40 work credits. Of course you do. I am 49, will be 50 in September. My new hearing over the phone is in March. Don't know if he's going to stretch 6 months. I don't think he can, to get you the age 50 amount to win on a grid if you are otherwise eligible for a grid based on your evidence. But you still have that other opportunity to win without the grid, of course. It's the winning under age 50, since the grid wouldn't apply for that. So I wish you the very best of luck in that. It's not fun, but if you still have insured status and it flies sideways, I would file again. And again, that's all part of that DLI, guys, date less insured. If your date less insured is after your ALJ decision, if it's a denial, you can file again for SSD. Whether you can file for SSI would depend on your financial situation. Thank you, Rockin. I appreciate. Oops. All right, Matthew. Hi, Matthew. I think we interacted, right? I'm trying to get my SSD lawyer's office to give me a written waiver for the representation of me and waive the fee. Yes, you are. All they've done so far is they sent me 5 medical source statements. They sent you 5. What do you mean medical source statements, Matthew? Do they want you to bring them to your doctors or something? Just curious. But I will say again, your SSD lawyer's office or non-lawyer representatives have every incentive to win for you. So there is that. Oh, right, Matthew. Matthew hasn't even applied yet. I'm curious what you mean by they sent you 5 medical source statements. Are they saying you take these and go get them filled out by your doctors? Yeah, if you haven't applied yet, you can pretty much probably escape them if you wanted to, but you might not want to. I don't know. All right. Christina, you're so cute. Oh, Zara, it's a she. Okay. It seems like a she name to me, but, in this day and age. Yeah, Matthew asks, all right, you guys, I have videos on this. When you have appointed a representative, you can always get rid of your representative, lawyer or non-lawyer. However, and I have a video on this, it's hard to get a new one, assuming you have a case the new lawyer, is accepting at that time, if your old lawyer does not waive fee. That is because the new lawyer won't be able to get the entire fee for himself or herself, but will have to split it for the other lawyer that did some of the work. I'm just going to say lawyers just so I don't have to keep saying lawyer or non-lawyer. Obviously, in this very low margin kind of niche area we're in, everyone wants to get a full fee, understandably, because if you don't, there's a good chance you're running in the red. So, and in the red is fine as long as you have plenty that are not in the red to make that balance. So a lot of people will not waive fee. I do it in some cases. I don't do it in others. It really depends on how the case went, the amount of work put into it, and the reason why the relationship is ending. So there is that. If you haven't applied yet, but you signed an appointment of rep, there's things you can do. Tell them that you are not, you're canceling your representation. You don't tell the SSA because it's never been submitted to the SSA. The SSA doesn't take and process 1696s, those appointment of representations, nor the 1693 fee agreements, unless and until it is attached to a current case. So in that sense, Matthew, if you tell them that you are canceling everything, I've decided not to apply with you, and I cancel this and put that in writing and send it in a way that they get it. I'm canceling this appointment of representation. You can file a little bit later and use somebody else or go pro se. Now, and they'll have no attachment, and you'll be able to prove if they ever did submit one. I think I heard of a case once where, despite being told the person didn't want him, the representative, and I don't recall if it was an attorney or non-attorney, went ahead and sent it in anyway to try to attach himself to the case, because once they are attached to the case, short of an SSA staffer who's deciding the fee petition later, paying close attention and really nitpicking it, they might just automatically give them half. It's a very unethical thing to do. But I think I did see that once. It wasn't I'm trying to think if it was a client of mine. I don't think it was. I think it was someone just showing me. But I don't foresee that happening, particularly if you wait a couple months. You'll be out of sight, out of mind. And if you have that proof that you sent them I'm canceling this, I'm not applying right now. And even if you are applying right now, you can still cancel it. But make sure you have that. Maybe send it certified return receipt to them so you have proof they got it. That way, if they ever do pull a fast one, which I'm sure they won't, that would be a very minority unethical group that would do that. You will have proof, and you could submit it to the SSA if it ever came down to it. Okay. Godiva. Godiva. I have a paralegal, but she said she does not know about the medical records. I am 58, COVID twice. Sorry to hear that. I think many of us, probably most of us, have had it twice, but it doesn't hit everybody the same way, unfortunately. Now a long hauler with severe depression, anxiety, fatigue, insomnia, migraines, 15 to 18 a month, memory loss. I'm so sorry. That is so unfair. I don't know what was your prior question, Godiva? It's not, I'm going to try to find it up here. Were you connecting it to that other time? Oh, about you're scheduled to have a CE exam next month and the doctors haven't received notice, you said. Paralegal does not know about, this is where I have a little problem where all you get to deal with is a paralegal and the lawyer doesn't poke his head in. It's, some companies, they're not lawyers. They are all paralegals. So, and to have a name like paralegal, sometimes I think in some areas, you don't have to have anything special. So it's frustrating. Maybe go ahead and call your DDS, ask her, are you going to call the DDS or am I, and see what she says. But yeah, sometimes you have to take care of yourself on that regard. Angie Vasquez, hello. You have a recon pending, but it's been a year. Just at recon level. Oh my gosh, I have one like that too. Not kidding. Just at recon level, then 6 months at initial. I tried working more than once, but one job was about $3,000 monthly, and I only lasted 3 months. Is that okay? That should be okay if you're otherwise found disabled, because that could be a failed work attempt, Angie. My suspicion is that the 12-month recon wait is because there's nobody on your case. Now, what you can do, because I have a veteran that's been, it's not quite a year, but it's getting there. I just drafted up last night. I did it in front of the fireplace with my laptop in front of the TV because I just wanted to have it ready to go for today. Something to his state federal representative saying, can you just lay a match under SSA to get his case worked on? Not trying to put the thumb on the scale of the merits of the case. You don't say, can you please tell them they have to award me? It's not like that. But they can light a match to get someone opening up your file. And I think that happens a lot when someone complains. So I just sent the release that the congressman wanted to my client for a signature. And then I'm going to fax it over to the congressperson. This is in a far distant state. I'm trying to think it was in Georgia. As you know, I'm in Pennsylvania. But we are in all 50 states, so never be shy. Just because you're from a different state. I probably have as much people outside the state as I do inside the state. And I'm from Jersey, and I'm a Jersey lawyer, so go figure. It's a whole different system when you work in the federal arena. Thank goodness, because remember I said I worked in the state area for the first several years of my lawyering. It was all New Jersey state. When I said divorces, I meant Jersey. That whole thing where you have to screw the other person to do right by your person. Not good. And it just never seemed to be a search for the truth and justice and all that good stuff. Even the lower level criminal that I did, nothing seemed right. I wouldn't be practicing law if I had stayed there. It was such a blessing when I accidentally stepped into Social Security world. Didn't even know it existed. Zara, you're going to be 50 in August. Okay, you're getting close. Okay, where am I at? Matthew again. Okay, so what Matthew was talking about before, his lawyers that he doesn't have a case with yet, but they're giving him directions beforehand, which is not a bad thing, except I don't do what they're doing here. It's just not my thing. You bring a medical, I have a video on this, guys, about why not to ask your doctor for a blank out, fill out a form. If you want to look at it, that is fraught with ways to kill your case. Doesn't mean medical statements aren't good to do later if they're tailored properly to your case and properly to that doctor's medical records. So they're not going to be blanket, off the internet forms. So I think that's inappropriate, because they wanted Matthew to bring a bunch of medical source statements to his doctors, which took me several months. I had them all filled out, meaning the doctors filled them out, right? I send them back, and their incompetence called me and accused me that I don't see the rest of your sentence. Yeah, that's a little difficult, Matthew. If you're a younger person under 50, and forgive me, I don't recall, was it like 44? I could be wrong. Don't hold me to it. I do know that that's sometimes a strategy to get a person off their back without having to say no. I don't think it's right. Just say no and explain why. I think your case is going to be probably not a winner at this point and this is what you could do otherwise. But, whenever I tell somebody that, I don't think the case is ready, I explain what I think they need to do. If it's something that I will take, if they do that, I let them know that. But if it's not, let's say I think that there's no way with their impairments that I just tell them, you could try, and then I would do this, but I still think it's a weak case. And, you just got to be honest, because otherwise you're having people chase their tails for no reason. And it's just ethically wrong. Okay, so Godiva again. She has a cane and a rollator, right? Godiva, I'm reading this right. It's a lot going on with me. Yeah, that is. I'm really sorry. Is it okay to call the adjudicator when I have a paralegal attorney in Georgia? I also have RFC reports. Well, here's the thing. When I represent somebody, absolutely not okay. Not okay with me. Is it a crime? Are they allowed to do it? Of course they can. If I find out they're doing it, I probably would withdraw. I just have this thing about don't screw up the case by going, because I do it all. Like, we do it all and we communicate it. So, when things like that are going on, like when calls need to be needed, we tell them we're doing it. When a client gets a phone call, they know to tell me, and I tell them, let it go to voicemail or take a message, say you can't talk right now, get their name and number. I will call them. My people don't even do it. I call them, because we need to know. I know exactly the reasons why they're asking for certain things. So when I find out what they're asking for, I know the reasons behind it. So I don't want anyone not understanding the reasons behind it, to inadvertently give information in a way that is not going to accurately reflect what's going on, and will put a fork in their case. But on the same token, there is nothing illegal about you doing it. It's your case. Could you tick off your paralegal / attorney? You could. Maybe ask them first. But in the end, it is your decision. I will say I'm not very tolerant of it. But again, I'm on top of this stuff. Like, I'm working on Sundays with it. I just love it. So, it's just different for me. So, and I make my own rules. So I don't have to be confined to, when I worked at a law firm, I was prohibited from doing certain things on a case because it was not a moneymaker in terms of billable hours. So it wasn't going to bill an hour. I wasn't allowed to do it, even though it was the way to get closer to the truth on the case. Like, so, it just was not, I don't work good in that kind of situation. but there's no law against you doing it. So just know, they might, if they're like me, they're going to say, don't do that. But they might be like, I know plenty of my colleagues who are like, yeah, go give them a call and let them know what your job was like. I would never let my client do that. Ever, ever, ever. In fact, we're going to put it in writing what your job was like and then send it up to them. Because there's going to be no manipulation or twisting of the words or anything like that. But that's me. So, and like I said, good lawyers, some of them don't do it that way. So I'm just a little more anal, and I'm sticking to it. Oh, DJ. Okay, hold on, DJ. I'm going to jump to you. Margaret, I see your post, but it's not a question. So I'm just going to, I assume that so other people could read it, right? DJ was planning on selling my home in Texas and moving to Colorado. So my SSI would be taken away just for that? No. No. People move all the time. There is, and I'm not going to have the dates on the top of my head because, again, this is outside the sphere of when I, what I practice. Your SSI, if you sell your home and you have money now, that would be a resource. However, if you're going to put it right into a new home, they give you a certain amount of time to do that. I want to say it's 3 months, but don't hold me to it because, again, it's not part of my job. This whole part of how people deal with their SSI after I'm long outside the, long gone, and no longer being paid to be the representative. But there is a time specifically for that situation, DJ, where you sell your home and the money immediately goes to the new home, rather immediately. I mean, obviously, nothing's going to be same day. So you do have to get your ducks in a row on that. And you might want to, depending on if you sell your home and you have, after you buy the new home, if you didn't use all the money from the sale of the old home because you bought a cheaper home, say, you might have a bunch of profit sitting there. If this is SSI and not Social Security Disability, DJ, that money is eventually going to bite you. So you're going to want to have a plan as to how to spend it down on smart things. And I know someone here asked about, can you do a video on what the smart things are to spend SSI on? I'm getting to it. I was actually going to see if Jonathan, we've been playing little email tag, and I think he's on tonight, Jonathan. We're going to maybe do one together. So we'll see. I would like to do it but I really want to get more information because I always look at the big ones. There's got to be other ones that are good too. So we'll see. We'll see. I'll hope to do that. But you definitely have some protections there, DJ, but just make sure you know what they are exactly. They're out there. I'm telling you they're out there, but you have to know them so you can fall within the parameters, and be mindful of where you're going. And if you did violate by a month or so, that just means that 1 month or so of SSI wouldn't be coming to you. It would be an overpayment. So just set it aside. But you don't want to have any overpayments if you can help it. So, great. All right. Where are we at here? Wow. Matthew's saying that he did get the medical source statements. He did send them to the lawyers that he was going to hire after they made him run around getting them, because they asked for them to decide whether they're going to accept his case. And then they said they didn't receive them. Yeah, that might be a paralegal that doesn't really know what she's looking at, Matthew. I don't know. I don't know what to tell you, but you're in a pretty good spot. If you haven't filed yet, might be the time to see the writing on the wall in terms of, who you got. Yeah, I get it, Matthew. You don't want to deal with their mistakes moving forward. Oh, great. So Matthew's saying he has a representative from Michigan that used to work at the SSA that's willing to take his case if I can get the waivers from my current lawyer. Yeah. But again, you don't even need the waiver, Matthew, meaning the waiver of fee guys if he changes representative, because he never applied with them. And I think you can escape applying with them. The SSA, they all differ, but I know if you have, like sometimes I'll get a signed 1696 from a a client that we're going to move forward together. But then, after I get that, then I have all this other information I need to gather from them. And sometimes it takes them a really long time, and we don't do anything until we have it all, other than communicate, on and off. So there are times when I have to send them a new 1696 and say, you're going to have to redo this because the SSA is going to take a 6-month-old 1696 on a case just getting filed now. So I just don't know if they have an official date, after which they won't, accept your 1696. It could be in the Palms. I just haven't looked for it because I just know if it's going to be long-winded, probably if it's going to be more than 2 months, I would get another one from them. Or if they're like left the date blank, and they're like, oh, I'm going to date it now, so it's all good. It's nice having things undated for that purpose. Oh, John Lantieri, how are you? One of my favorite people. How are you, bud? I'm going to share. You are really sweet. I was approved for SSD about a year ago. I'm turning 65 this year. My situation, although mildly improved, I still have the main complications. Is a review coming? John, check your award letter. Does it happen to say a diary date? I think that you're probably golden, particularly if you didn't win a long, long time ago. Yeah, I think you're probably golden. I wouldn't sweat it. You're going to the doctors anyway, right? Because you have medical needs. Just continue with your complaints of how X, Y, or Z affects your day-to-day still, and I'm glad you're mildly improved. That's awesome. So I don't really see a big problem. But I always want everyone to dot that I, cross that T, and even if a CDR is unexpected, because you could have been on a 7-year, John, right? 5 to 7 year, in which case you're not going to have a CDR. And you could call the local office and find out if it's not in your letter, which it probably isn't. I know someone who called and they said they gave some hogwash about everyone's different. We don't know when yours is. They do because it's in your file. The file they didn't show you. So they do have a diary date for everybody. Yeah. So I think you're probably pretty safe, John. But as you need to anyway, just continue with your doctors. Be frank about the things that are not getting better. Okay. And if something is only mildly improved, don't say, doing great, doc. Right. All right. Who are we at? Enrique, age 58, ALJ, April. Is that her name? His name? VA 100%. Thank you so much for your service, Enrique. My favorite people, along with police officers, actually, and other first responders. Arthritis on both hands, back pain, anxiety, depression, hip arthritis, all medical documentation. Sorry for your issues there, Enrique, but I'm glad you have medical documentation. And remember, medical documentation from the past is not current medical documentation, guys. So while it can be good for showing the progression and how long it's been going on and all that, you still need to have current. Just throwing that in there. Unemployed, will this conditions be good enough for favorable findings? That will depend, Enrique. I mean, with regard to the grids, you're 58. If they show that you cannot do your prior job, which is something in the last 5 years, and if they show that you cannot do more than light work, so you're relegated to light or sedentary, and it shows that you can't transfer the skills from your prior work of the last 5 to one of those sedentary or light jobs that exist, you should be able to prevail on the grid rule that would apply to your particular age group. But that will all depend, of course, on your medical records. not just the fact that you have medical records, but what they say. So if you don't have an attorney, I suggest you reach out just to make sure. I assume you've already filed, right, Enrique? But if you don't, either way, I wish you the best and the best of success. And I hope your medical conditions get some relief. We have one life, right? Let's make it as best quality as we can. Salvatore, let's see if I can. It says, any hope the tax schedule on Social Security might be adjusted to reflect today's income standards. I'm not sure which tax schedule you're talking about. If you're talking about the current administration's push to relieve Social Security disabled and retired people from having to pay income taxes on their Social Security benefits, which they would be paying based on their own tax bracket, that tax schedule, there's big hope, actually, that could happen. So fingers crossed for that. There's a couple of things this could be about. The schedule, if we're going to call that, for combined income, which says if you're a single person and your income, including the portion that is counted from SS benefits that you receive, is over $25,000, you're going to get taxed. 50% of your Social Security is going to be taxed. That $25,000 has not changed as long as I've been practicing. So no COLA has applied to it. It has not been adjusted. Maybe that's what you're talking about, Sal. I haven't heard anything, but I haven't really been keeping up on my inbox with those kind of things. And I don't know that, but I think I would have heard the scuttlebutt about anyway. They need to apply COLAs to all these things. It's really pathetic. It's just not ethically correct to say that someone needs to have at least 25, 30 years ago, but that never has to change. What? Because the 25 is like it is today? Not. Carl M. Hi, Carl. Hi, I took a psychiatric. Hi there to you. I took a psychiatric test and a psych test for intelligence. Why did they give me 2 tests? Oh, it sounds like you had one for like maybe mental health struggles and one for cognitive loss. Maybe if you or your medical record suggested that you had memory loss or cognitive difficulties, that could be one. So that's, having 2 is not a bad thing. So can a 100% disabled person on SSD get any extra tax break from the IRS? Can 100%? Well, we already know if your SSD is low enough, there's no, you're okay. Federally, the income tax standard deduction is like $29,000. So for the first $29,000 of taxable income that we bring in, we don't pay any federal income tax. That was a result of the 2017 tax reform. That was great for us littler folks. Lower income, middle income people, like probably most of us here, including myself. So if your SSD is less than $29,000 a year and you don't have all this other income that would put you into a more wealthier income level, you're not getting federal income taxed. There's 40% of people or more, and that's probably like a year-old number, that get federally income taxed on anywhere between 50% of their Social Security to 85% of their Social Security benefits. Income tax is applied to it. But for the lower income people, because of that, let's be clear, because of that tax reform of the 2017 tax cuts, when someone says to you, oh, it only helped the wealthy, precisely that is not exactly what it did. In fact, there are so many that benefited myself, my family, and definitely my clients. But a bigger help would be if it helped the other people, the 40% or 50% who are still paying taxes on their Social Security because their combined income, maybe they had some retirement that they've been saving. They start taking the distributions, and now they're finding that because they went over that $25,000 a year, now they suddenly are with the combined. Now their combined income is enough to trigger the taxation on their Social Security benefits and all that. So, but prior to the tax cuts, a single person, well, 29,000 deduction is for married people. It's 29 and change, I think, this year. And prior to the tax reform, it was 12,000. So it's definitely they doubled everything basically. So you didn't have to pay tax on twice as much of the first money coming in the door. Okay. So that would be a tax for someone on SSD. The proposed tax elimination for disabled people on their Social Security would definitely help all disabled people on Social Security disability who are otherwise subject to tax. And I will add that higher, well, I'll scratch that. I won't get into it. Zara, why addicts get Social Security? Well, I'll tell you. Being an addict doesn't make you undeserving of Social Security. Now, if you're saying if an addict back when an addict was using caused the disability, which is very possible. I've had many, many clients who are very disabled with some significant mental health and cognitive issues due to prior use. Remember, addiction is not really a choice. It was a choice to play with it. But like many of us when we were young, and I didn't do drugs, but I tried cigarettes and I got hooked. It is a monkey on the back, as my father used to say. But assuming a person initially has stopped using and is just an addict that's in recovery, if they are still disabled because of the damage that was already done, yes, they do get Social Security if they paid into it, and if they are otherwise eligible, which means that recency test too. And if you want to look at it a different way, many, many things we all do cause our disabilities. Some of us, this is for those of us that are not disabled through genetics, right? Some of us go skydiving and we fall and we're disabled. Now we caused it, right? But does that mean we don't deserve our Social Security that we paid for if we're otherwise eligible? I don't think so. And you could say, well, addiction is illegal. One could say that, except oftentimes it's not. There's a lot of people addicted to legally prescribed drugs that their doctors prescribe them. Some became hooked on a drug when they were minors, and that means there was no consent there. Keep in mind, too, there's something called DAA, and that is when a case can be denied for a person who is an addict or not an addict, but is using drugs in a manner that tells the adjudicator or the ALJ that but for the drug use now, today, that person's keeping themselves disabled. If they stopped, in whatever fashion they have to do it, whether it's with Suboxone or cold turkey or however it works, if they stopped, they would no longer be disabled because they could probably engage in a simple, easy minimum wage job full time. They're not going to win. DAA is going to be a bar. Once they're found disabled, DAA, and that's for current usage, guys. So don't worry if it was usage from before, but now you're clean. I've also seen, of course, many a clean person fall off the wagon. Many of my clients have. It's a tough thing to, recovery and dealing with an addiction, which I agree is an illness. It is an illness caused by what we did, but we didn't even realize we were getting addicted, right? And I always chalk it up to my cigarette habit. And I did quit back in the year 2000. So, woo, empowering. But it's that's a little bit of a different situation. That wasn't illegal, and it didn't, it kills you. My mother-in-law just died from cigarette smoking in a very painful, horrible, year-long plus manner. But if you're on the wagon and you're substantially on the wagon, and I have found that a rare relapse is not going to necessarily kill a case, because we show that it is a rare thing. The person was disabled before they relapsed, and they're disabled after it, not just during the relapse. So there is many ways to fight that, guys. I'm going off of Zara's question about why addicts get Social Security. And that's because it's for people who are currently disabled and aren't currently making themselves disabled. So look at it that way. You know, people who eat all crappy processed food, like many of us do sometimes, some of us do it all the time. A lot of our heart issues are caused by what we eat. Little did we know, we were kind of snookered, but you know, so our disabilities are often caused by our own lifestyle choices. Doesn't make us bad people and doesn't make us not disabled. It doesn't mean we didn't pay in. I would say most of our disabilities are caused by our own choices. They were largely uninformed choices, I will say, particularly in the eating regime. But, you know, the foods that are found in our grocery stores that the FDA does not say we can't have. So, you know, all right, addicts, you got my support, peeps, as long as you're doing your best. I'm in jurors at go. I don't know what that means, Sarah. Okay. Hi, Catherine Cooper. How are you? When Social Security says they will pay up to 1 year back pay, when does the 1 year start? And what does the 5-month waiting period mean? Okay. So the date of application, going back 12 months, is the earliest date you can have a back benefit month. Okay. And of course, you have to otherwise be eligible for it. Well, that means you can't be in your waiting period in that month, number 12, prior to the date of application. And you can't be in your waiting period, and you have to have been found disabled by then, right? I mean, just because it's 12 months prior doesn't mean you're going to get it if you were not disabled until 6 months prior. So that is the 12 months. It's 12. You have to have, they will only pay up to 12 months of benefits in the months that you were disabled prior to your application, if you are otherwise eligible for those back benefits, such as being found disabled those months and not in the 5-month waiting period. The 5-month waiting period is just that. It is from the date, it is generally from the date you are found disabled. So I found you disabled 3 years ago. Well, the first 5 full months, let's say they find you disabled in January of 22. Your 5-month waiting period would be February, March, April, May, June. That has to pass, and then you're eligible for a July payment, which, by the way, will probably be paid in August if you're not ahead of that time yet. Otherwise, if it's way later, it's going to be in your back benefits. So it's 5 full months of a waiting period, guys, and so that means you're not eligible for a payment till the 6th month, in essence. And the month you become disabled doesn't count in that 5-month period. Okay. Let's scroll down. How's everybody doing? I hope you're doing well. It's so cold in this office. I'll tell you, we have like zero. We had -9 today, this morning. I actually drove my kid to the bus stop. They had a 2-hour delay because I think they're not sure the buses are going to start in this kind of cold. Hi, this is Terry again. Is having heart disease and uncontrollable diabetes, foot pain, taking insulin, and pill and back problems with pain management, right and left shoulder, torn rotator cuff, high blood pressure. Are those things that could be disabling? Absolutely. It will all depend on your evidence, as well as your vocational profile, which largely means your age and what kind of work you did in the last 5 years. Art of practice. Any suggestions on where to find a short 1 or 2-page functional capacity form that is targeted for lower extremity issues? I do not. I draft up my own. There actually would be called a medical source statement. Art. It addresses functional capacity, though, obviously, but the functional capacity form is really the big one that the SSA fills out once they've reviewed the records, and that's their final finding. So the medical source statements are your doctor's opinion on the various issues. I draft up for my clients that could use an MSS, and it's not every case, I draft them up for the doctor. I stem it from the doctor's own records so that it will always be well supported by his records, as opposed to being something he's never discussed, because that gives it more strength before an ALJ, or, at an earlier level, if it's appropriate at an earlier level. And I do agree with you, though, that short 1 or 2 page, I try to stick to 1 page, because when I draft these things up, and it takes a while, this is not something that can happen in a half hour. Probably hear all the birds and dogs. It's probably the UPS man here or something, FedEx. You have to go through the records. You have to really kind of tailor it. And, it's, keeping it short is a good thing, because your doctor's not going to, people send that big 9-10 page generic one you find on the internet, and they send it to their doctor, and their doctor's like, yeah, not doing it. I mean, why would you send him questions about your back if he's a podiatrist? That would be your back doctor. So I think it's a great idea that you're trying to tailor it to targeted areas, like a lower extremity issue. It's very, very, very wise. But I do not know such a form. I don't know that I've actually done a lower extremity issue. I have, in particular, although I suppose I just didn't call it that. So maybe. I have ones about, I've had people with lower extremity issues in the fact that severe pain and edema, and they had to go and elevate their legs multiple times a day, but there's nowhere in the doctor's record where it says exactly how much he should be doing it. It might say he does elevate and leave it at that. There's no, it's medically necessary noted in there. And he's just saying what the guy told him, what the patient told him. And it doesn't say how often, it doesn't say, and I recommend this. Sometimes I tell my clients, talk to your doctor and say, hey, can you recommend to me in writing how much I should be elevating my legs? Right now, doc, I'm doing it every hour and a half for 40 minutes. And by the time the next hour and a half goes by, my legs are, do you think I should be doing it more often? Do you think it would be more appropriate for me to be doing it for maybe elevate for an hour and 15 every hour and a half? So you're almost like 50-50 on your feet and off your feet. But some people have such severe swelling and edema that's really what they have to do, even when they're on the water pills and the cardiac and all that. So every case is different. But if it is, and if you're finding yourself having to be in a recliner with your legs elevated up to your heart that much, it's a really important disabling symptom, because it's taking you out of the work postures, and no job entails doing the job from a recliner. So that would show that you can't do 8 hours on your feet, 8 hours sitting, or a combined sit-stand for 8 hours, because you have to be reclining for 3 or 4 of them. Cindy Gertman. Hi, Cindy. We may have talked before, I'm not sure. The New Fairness Act. I will be affected by the New Fairness Act. I worked and paid in SS for 10 years and also worked for 30 years not paying into SS. If you didn't pay into Social Security on your teaching job, Cindy, compared to like your fellow teachers who did pay in, yeah, it's going to affect you. You're going to be able to pull more Social Security dollar for dollar, percentage-wise, than your counterparts who actually paid in. It's very interesting. But yeah, you will. It sounds like you will be. If you were being affected by the windfall elimination provision, they are now taking the windfall elimination out of it and allowing the windfall, so you will get the windfall. There is, okay, she's asking now if, how do I figure my SS if I was affected by the new, they have, I've heard they have a calculator. So do maybe a search on ssa.gov for WEP calculator. And I think you can probably throw in some numbers there. that you are aware of that are your personal numbers, and they should be able to tell you. We had a guy, I don't know if it was here or on a video, that said he did it, and he learned he was going to get like an extra $47 a month or something. So he wasn't getting much because he wasn't affected much because he had had 28 years of substantial income outside of the non-SS paying job with the government. So he was a really robust worker on two different, almost like in two different careers. You're welcome, DJ. All right, Matthew, I get it. Yeah, and Matthew, try not to go too lengthy because then I have trouble finding them. All right, Cindy, I'm not sure I can answer this. How will my average income be figured if I paid into SS for 10 years and then I taught school and did not pay S? How will my average income be figured? It is going to be on your SS only work still, like it was before. However, what they're doing is instead of like you and all your fellow school teachers got, say, 25% of your average income, which is over your lifetime, top 35 years, your average monthly income, say you're getting 20% as your Social Security benefit rate normally, when you're not having that second job where you don't pay them. If you were paying. When you weren't paying for the job, how do I explain this? All of you that made the same amount of money, but you didn't pay Social Security taxes and they did, they're getting the 25%, something like that. You are going to, on the stuff, they dollar for dollar on what they paid in Social Security wise, you, because of this removal of this windfall elimination provision, you are now going to get probably like 55, 60%. Simply because you didn't pay into it. It's kind of weird. Yeah, weird. I'm glad for you, Cindy, though. I like to see more money into nice people's pockets. I just have a big question about the ethics like this one in terms of the government doing this. Okay. Oh, rockin'. Do you go live with Jonathan? If yes, will you please tell us his channel? Or is there? Oh yeah, Jonathan Ginsburg. He's on tonight. I don't think I'll be doing it tonight. I have a colleague meeting at 5:00 that we Zoom with that I've been doing since about 2021 with Social Security disability colleagues around the country, and we have not had one since September because I was really wrapped up in some other things, as some of my clients here know. And maybe some of you guys, and then it was holidays. So, and I was actually trying to get one of my colleagues to take it over so I can just pop in when I want, because it takes a little time. But anyway, I am doing that tonight at 5:00, and that's just with the colleagues. Jonathan Ginsburg, look him up. He's fabulous. He's a super guy. He's been doing this even longer than I have, not by much, but somewhat, meaning SS work. He's been YouTubing for a long time, way longer than me. Yeah, I promise if you look him up, you're going to see him rocking. Jonathan Ginsburg. You just put it up in the Google little thing up there, and he's going to pop up. He has a lot of fans. He's really good. He's a good guy, and he's kind, and he's really competent. So I am not going live with him tonight, like I said, because I have my thing I have to do. But I did do it a couple weeks ago with him, maybe 2 or 3. I'm thinking 3. Definitely in the last month, I think. Time flies, but it's not that long ago. So I'm one of the live ones that he had recently. Brad K. Hi, Brad. We applied for SSI for my disabled son after he turned 18. They approved it in 5 days. That was about 4 years ago. So now he's 22. Just filed for my SS at 62 and for him to be switched to DAC, waiting for 45 days. Oh, did we talk already, Brad? Did I see this? This looks familiar unless it's somebody else. Yeah, I mean, 45 days with this staffing here now, the last few years, that's not really that long. So I wouldn't worry too much. And he got the SSI as an adult. So I think the chances are good that the DAC will come through for him if he has a condition that he had since childhood, but couldn't get SS during childhood because of parental, wherewithal. You guys had jobs and such, and we're not poverty stricken. So he got it as an adult. The same standard applies. So I think even if they review him, I think he'll be just fine. In all likelihood. And remember, always have a little bit of follow-up with whatever medical condition it is. Even the ones that are not curable, but sometimes a little examination from an expert in that field to show where the person's at and where the deficits are can be a good thing. Every few years. That's just the cautious me, Brad. Yeah, John, continue with those doctor appointments. Spot on. Angie, is there a spot at DIB? Yes, there is. DIB, guys, is Title II, Social Security Disability Insurance Benefits, Disability Insurance Benefits, DIB. 48, you've got that massive mountain to climb. So spondylosis, it really depends on what the rest says. But, practitioners can differ on what they think is serious enough to win a case when it comes to a back spine problem. I have a case that a wonderful colleague of mine didn't think that the MRIs were significant enough to accept the case, but I saw a lot of promise. So everyone has different ways of reviewing things and finding their different, practitioners of finding their different paths to an award. So everyone can feel differently. Now that person was not 48 years old. You do have that uphill battle, and it is really hard. I've got the greatest of compassion for younger people. I always have to reiterate this, though. It's almost like I'm a complete nag on this. Angie, check your DLI, date last insured. See if it extends well past 50. Depends on when you stopped working, of course. And if it is going to end before you can prevail, and you won't know that. So I always suggest, if it's possible, to work a very part-time within the parameters, carefully and mindfully. Know the rules. It's very easy to stay within them if you know them, and keep those credits coming. The minimum you need to keep those credits coming so that you do not expire your date last insured. Your window never closes. So that if you don't prevail at 48, 49, even 50, you can keep applying, and you will. Unless you recover, you will prevail eventually, as I see it. Okay. Unless things start getting really good for you, in which case that would be even the better solution, right? I'm sure you'd be dying to go back to work. Oh, Freebird, you're so sweet. Thank you. Very, very kind. Thanks, bud. Hi, Gemini. I see your issues. I don't see a question. And that's okay. Maybe you're just sharing it with others that might have the same problems. So this is a good question. Comment 52. What is the likelihood of getting a review if your SSC started past 50? In many cases, I think it's going to be slim, but there are going to be some. It depends for some people. It will depend on what their SSD was based on. Some people have an acute problem that de facto takes them out of work for a year, but they're expected to recover. It could be a car accident. I'm thinking a transplant too. So if, and then it depends on what your other impairments are. If you have a bunch of others, then it's a slimmer and slimmer chance of getting overturned on a CDR. The getting a review. Now keep in mind, there's I think they do a quick little glance over, and you might not even know about it, and they just bypass the CDR if they don't think it's necessary. So there's like a full-blown CDR, and then there's the internal workings of the SSA. Sometimes there's that short form, long form. So I think there's always going to be an eyeball that you're not even going to know about, even if you're over 60. But the chance of getting a review will depend. I think you're going to get that scan over that you're not even going to be aware of. And you know, if you're on a 1.5 year diary, you're probably going to get the CDR. So just, you know, if you're following up, if you're still disabled and you haven't improved notably, then you are going to be going to doctors, right? You know, maybe not to the same extent as when you proved your case, but it's presumably something needs treatment or medications or monitoring. If nothing else, guys, go for a follow-up monitor, you know, periodically. And when you're there, you complain about all those limitations that interrupt your day or make things unpleasant. And sometimes it's hard to remember because when we start getting limited, I think we get a new norm and we think we start to forget that it's a limitation. So that might take a little bit of sitting down and thinking about it. Maybe jotting it down so you don't forget. And yeah, I think so. You know, I didn't bring my water in. I have my cold coffee though. That might help wet my throat. All this yapping I'm doing. Lulu. Hi, Lulu, and thank you. Your question is, from workers in a CR settlement. Are we talking workers' comp? I got $85K. If I were to be approved, will SSDI take the whole $85K or a percentage? You mean from your workers' comp settlement? They don't take it. They would have to offset future benefits or your back benefits if you win your back benefits. So if I were to be approved, so you haven't received your SSDI yet, it's taking longer. So basically, and I don't do workers' comp, but I just have a lot of workers' comp clients, and I always kind of defer them to their workers' comp attorneys for the workers' comp information because outside my scope. But there's the 80% rule. So when they figure out what your ACE is. I want to say average current earnings, that stands for. And that is usually the few years before you stopped working. So, which is presumably your highest years, but isn't always necessarily. So they find out your average earnings by the month. And whatever that is, take 80% of that. Put that number over here. 80% of your average earnings. Then for every month that you get SSDI, either a month retro or going forward, and you had workers' comp, either in lump sum, retro, going forward, backward, whatever amount of the 85 is attributable to a particular month, add it to whatever you got for SSDI for that month. If that amount, and this is just a generality, guys, if that amount exceeds 80% of that ACE, that number we're sitting over here, then the part over the 80% has to be withheld from you. It is some sort of, in a sense, a windfall elimination thing, in that the theory being you really don't want disability to provide people with more money or the same money as when they weren't disabled, because the incentive to become disabled and to commit fraud would really be heightened. Is that true? I don't know, but it stands to reason. And that's pretty much why. So you're going to have to do a month-by-month analysis when you figure out what months that workers' comp amount applied to. Okay? And spread it out and figure out what amount per month. It can be a little tricky. I never do anything firm on that. I've evaluated it with people in consult so we can get like a ballpark of worst case scenario. But you almost don't know until the numbers come out. Oh, Zara, I know you didn't say that they, yeah, Zara's saying, not saying they're not deserving. They don't go through the same BS It's like they, oh, no, that's not true. It really isn't true. I think they probably go through worse scrutiny, at least in my experience, because I've represented several and still do. They just can't be currently using, obviously. But they don't automatically get it, but you have to gotta remember that mental illness or mental cognitive damage is often not visible. It isn't. It's inside. It's inside their heads, their hearts, you know, and or their organs. And the amount of cognitive damage that can be done, and sometimes it's something as far as schizophrenia. We never know what came first, the schizophrenia or the egg, but like, did the schizophrenia cause the drug use? Did the drug use cause the schizophrenia? Not sure. Perhaps both. Perhaps it happens both ways. If their mental state is so bad, let's say they're in institutions twice a year and not rehab to get clean, because that would mean they're still using. They're going to have a higher chance of getting it because they're going to be completely unable to perform any job full time if they mentally can't do the tasks required, including showing up for work, not getting distracted, not hearing, hallucinating audios or visuals, being able to deal with their coworkers and supervisors. So there's a lot of reasons, and they really don't automatically get it, though. And ask anybody who has had serious mental health challenges, including, and many of them do, include prior drug addiction or overuse or whatever. They sometimes have to apply more than once. If they're young, they often won't get it because, they're not hospitalized. Why can't they do at least a simple, easy job without stress and not having to deal with the public and all that kind of stuff? So I have to tell you, my longest fighting cases are these folks. So it's not automatic for sure. Older people, if the grids apply, it can definitely be a lot faster because the different rules apply that make it easier. But maybe that's who you're referring to, is maybe some people over 50. But for the rest of them, it is a battle. Matthew. Yes, Matthew, this is true. According to SSA regulations, in certain situations, individuals between the ages of 45 and 49 may be considered more limited in their ability to adjust to different work compared to or akin to those between 50 and 55. Right, Matthew? That's true. I've never seen it applied by the SSA in action. Nope. And I've tossed it out there a few times to them. So I think that's very, very rare. Very, very rare. So rare, I haven't seen it in 20 years. But because remember, that's not a person who wins on mental health under the age of 50, because those people with very, very severe disabling mental health conditions, and only mental health conditions, do win at times. This adjustment to different work would be for the person who is not that bad because they didn't win that way, but they're trying to it's almost like a grid area for them. And it is exceedingly rare, in my opinion, in my experience. Oh, Angie, it's okay. I understand. I was just explaining, but I do get it, Sarah wanted to make sure that everybody knew that, she wasn't saying addicts don't deserve it. And I get it. Thank you, Angie. And Sarah, I totally get it. All right. Moving past on. Matthew, I got your post here. And yes, there is that. And that is a battle to be made. It's not one that's readily, like I said, readily accepted by the SSA, but it exists as a rule, just not one that's applicable generally. Hi, Joshua. Sure. Hi, says Joshua. I had a question and was hoping you could help. I was asked to attend a telehealth mental CE. I wrote down that I don't have valid ID as I'm unable to get one. Will I be asked to attend? That I don't know. My bigger concern is, can you ever collect disability benefits if you can't prove who you are? That you're not a scammer, that you're not just some person pretending to be Joshua. I think you need to get onto that valid ID thing. And that's not a real ID. You know, if you need to get a valid ID, and the rules have probably changed a bit, but you can go get, presumably, you can go to Vital Statistics in the state you were born and get a certified copy. You're going to pay a few bucks for your birth certificate. And then go to DMV and figure out how you, they're probably going to ask for proof of address, some mails coming to your house, maybe 2 of those where, your electric bill's in your name or some other, relevant bill. And then you can get a driver's license with that birth certificate information. You will have proved you're old enough to drive. You will take, if you haven't done it already, well, you haven't, it looks like, you will take your driver's test and get a driver's license, or just a state-issued photo ID for the non-drivers. That's fine too. You have to do it because I don't think they're going to pay you. It doesn't matter whether you go to the CE exam if you win and then they don't pay you. And then enough time passes and now you have to restart the whole thing anyway. So get your birth certificate. The worst and last case scenario is when you have to actually go to court because maybe you're like, they say that they don't have my birth certificate. It burnt, the warehouse burned down long ago, whatever. You can also talk to the hospital where you were born, if you were born in a hospital. Sometimes they will look at, and you're going to have to do the research on this, but it's out there. There's alternative ways. They're more arduous to prove identification and get an ID. Sometimes it's proving baptism records help. But again, if you have that birth certificate, your DMV website is going to say all the things you need to get a state. Let's just assume you're not going to be driving. A state-issued photo ID. Birth certificate. I'm pretty sure it's mail. My husband worked and supervised the DMV, so I'm trying to remember. But I've read up on read up on it in the past. So you definitely want to read there and get those ducks in a row. It's a little process, but I mean, you are responsible for in getting that stuff, and you can do it. I don't know about that CE. You said no ID. That could be tough. Maybe they'll take something else. I don't know. Okay. But you got to get an ID. Get a state-issued photo ID. Use that birth certificate that you're going to get if you don't already have it. Maybe you have it at home. And go get it. You don't have to be a driver to get a state-issued ID. Okay. Good luck there. Matthew, about the 45 to 49 rarity, about adjusting to other things. I don't know if it's that number. It probably is if you say it is. I'm not looking it up right now though. Okay. And I don't usually look up stuff unless I'm going to go into it. And it's so rare. I really, maybe I'll do a video on it in the future, but not today, of course. Right. And Zara, yeah, I know you're not yelling. I'm cool like a summer breeze. You're just in all caps. That's why they're saying that, honey. You got your caps on. Thank you, Christina. You're welcome, Zara. I know you're worried, Joshua. You got to go get that state-issued ID. Miss V Designs for you. Okay, how are you? I'm currently receiving SSDI since 2021 and will be 65 in April. My benefits were reduced due to WEP. Will I receive an increase due to HR 22? I assume by HR 22, you mean the Fairness Act. yes, you probably will be. If it was reduced by WEP, you will probably be getting that windfall back again. Benny, how are you? Benny DeMarble. How often do you work with helping disabled veterans get SSDI? Are the outcomes positive? Yeah, I have a very positive outcome, but I work like a freak on my cases. I'd say probably half or more of my clients are veterans, maybe half. Godiva. On a couple of my med records, it shows I have my bachelor's degree, which is false. Yeah, those doctors, right? They can't quite get it straight. 27 years in property management. How do I handle this degree thing? When you, I don't know if you filed where you're at. I don't recall if you said, you could say it right in the remarks section of your application, or SSA 3368, the medical portion, wherever there's remarks, you can say, I do not have my bachelor's degree. And by the way, the section where you do put your education, put what it accurately is. I do not have my bachelor's degree, although many medical providers have misstated that. And if you really wanted to be anal about it, but I don't think you have to be, because honestly, if that bachelor's degree is a few years old, it's moot. It's not very relevant. What's going to be more relevant is the work you did in the last 5 years. So, but if anytime there's a misstatement in a medical record, if it's really getting, a real bug in your crawl, everyone has the right to ask their medical provider to correct the medical record. And they would be stupid not to correct that one. It doesn't even affect their ego, their medical diagnosis, or poorly described symptoms or whatever. So, but, they don't seem to take a lot of time to do that. And there are rules where they have to, I believe, note that you asked for something to be corrected, even if they don't correct it. You can't force a doctor to correct a medical record he thinks is accurate, but you can have your statement that patient says that this is inaccurate and blah, 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 and asked us to change it. And we declined. Fong Chuang, am I saying that right? Forgive me if I butcher it. Okay, thank you for your service, I believe. Migraines and anxiety, and looks like major depressive disorder. DDD, is that degenerative disc disease, Huang? DDS medical expert requests a physical examination to determine if I am a sedentary or light work category. Whether a grid rule applies, Huang, would be based on your vocational profile, mainly your age. And then it is important to find out if sedentary or light, that will be critical, but they also have to determine if you can or cannot do your prior job, and if your prior job's has transferable skills that can transfer to sedentary light job that you could physically do. Okay? If you need me to take a look closer, or you need assistance, reach out. And I thank you so much for your service. You rock in your sacrifice, my friend. Oh, Zara, fun question. Why did they stop mailing out what you would get from Social Security? If you're referring to the mail that we used to get a few months before our birthdays, it was called the Social Security Annual Earnings Statement. And we used to get it mailed to us a few months before our birthday. They stopped that back under, I will say, I thought it was a great budget cut by the Obama administration. It was a sound decision to do, because most people toss it, particularly young people who don't realize how important it is to know that information and perhaps keep it in a file. I was one of those young people, by the way, that threw all that stuff out. Crazy. But, because we just think the world's going to rock around us. Yeah, no. So they stopped mailing it, but they put it online. So you can go right online. Currently now you have to go to login.gov or id.me. I use the former. I just did it for the first time recently. I was a little afraid. And you can get it there. So if you have, by the way, if you have already filed if you have a pending claim for disability. I'm not sure if it's the same true if you have a pending claim for retirement, but if you have a pending claim for disability, you can get that statement, but they're going to eliminate the part about what you can get if you become disabled. It's no longer included until maybe after you get denied or something and don't file an appeal. It will, though, have all of your annual earnings from the time you were a wee one, all your Social Security earnings listed. So it's a great way to check to see, where it's going, and whether anything's missing, something didn't get filed properly, and you can then fight with the IRS to get that properly reflected if there was some faux pas that went on. Hi, Deb. Yeah. Deb says, I really like Jonathan, not just because he agreed with me on a few occasions, but we always love that, right? Yeah, he's good. He's really good. He's very thoughtful. So I adore him. I hope to see him soon. Okay. But not tonight. I can't do the live tonight. Brad K. Assuming Trump can get past the elimination of taxes on SS benefits, then the 25K 34 numbers, he's referring to the combined income limits that have been stagnant for decades, for triggering tax would go away and would not need to be adjusted. Yeah, unless the combined income is used for other things, like some states, instead of devising their own system, they say we use the federal blah blah blah, unless there's something like that. But yeah, I tend to agree with you. I think off the cuff, I think you're right. If the SS taxes get eliminated for disabled and retired people, so they don't have to pay income tax, well, the combined tax stagnation of never adjusting those numbers according to reality not need to be adjusted. I think you're right. That's my initial take, Brad. Good point out. I love that. You can come back anytime. Just kidding. Terry, do SS pay you when you apply or on your AOD, alleged onset date? My alleged onset date is 2019. My application date is 2022. I have medical records for 2019 as well. All right. Is it Social Security disability, Terry, or is it SSI? If SSI, they will not pay you anything before the date you actually applied, assuming you prove you were disabled as of that time. If it's SSD, they will pay you up to 12 months prior to your application date, assuming none of those months are within your waiting period. So with an application date of 2022, you're not going to get SSI prior to 2022 at best. It'll depend on your application date and or when they found that you were disabled. If it's SSD, they could go back to 2021. But I would give them those 2019 records. Everything, but I would give anything that's at your AOD and a few years before your AOD, and in less common situations, sometimes really old records are important. Like, a lot of times for like cognitive mental health stuff, we can show stuff in high school. There was an IEP, and what was going on there to show that this wasn't something that we just started saying recently. People, might say, I have a learning disability, but then there was no treatment because do you really treat for that as an adult? Probably not, but you could show it from IEPs. And they might choose to give you a cognitive exam, maybe, but maybe not. All right, moving on. We're coming up on 2 hours, guys. Time flies. Matthew, I have a very important question. I'm firing my lawyer and trying to switch to Dominion Disability Advocates out of Michigan. The doctor there used to work for SSA, who is now SA. Okay, well, that's good, Matthew. I think, and we talked about how you haven't applied yet, so I think you got a lot of room to do this. My question is there any situation where I would not want an SSA certified advocate instead of an actual disability lawyer? Oh, I have some great non-lawyer disability colleagues. So are there other reasons separately from the good ones? The only big glare that I have is I really do think law practitioners stand on their own. The only thing about the unknowns, like if you don't know the lawyer and you don't know the non-lawyer, the only thing I can point out, aside from have they been in the practice long, you know what I mean? How's their reputation? Do you know people that use them? You know, if you know someone who used them and they can tell you what their practices are like, you can see if that is something you like or don't like. But the big thing is, that's kind of like the elephant in the room, is that lawyers can get disbarred if they screw up. A non-lawyer rep isn't a lawyer, so they can't get in trouble with their state bar and lose a bar license. It's kind of like the bigger you are, the harder you fall. So there is that. A advocate that's not a lawyer can't take your case to federal district court, but that's not really such a big deal, because honestly, I send any and all people that come to me saying, I need to go to district court, will you do it? And I won't, but I can refer them to people who can look at their case. I, on very rare occasion, have to, give information to one of my clients that didn't prevail through ALJ or AC and wants to appeal to federal court, and I give them a name of a colleague to do their due diligence and take it up the pike. Those are all going to be lawyers. There's not going to be non-lawyers doing that. Okay. But again, I have excellent non-attorney reps. A lot of the excellence comes from, I think, a mindset, honestly, because they're all smart. Anyone who gets in there's got the smarts to do it. If they've been in it for a few years, they've learned and whatever. But it's the mindset. If they're gonna, if it's all about doing less work to get a fee, it's not going to be good. They're going to have a low win rate, and nobody's allowed to really publish win rates. So at least the lawyers can't. I don't know about the advocates. They don't have the bar rules to deal with. But I kind of think word of mouth is good. If you know someone who used a lawyer and they were thrilled with them, not just with the result, but with the way the case was handled diligently, like the case was important to the lawyer as it was, or the non-lawyer as it was to the client, that's, I don't know, I kind of think word of mouth is a great thing. Let's see. So I hope that answers your question, Matthew. They could be very, very good. And he did work for SSA, so he's got, at least he has some experience with SSA, even if maybe not a lot on this side of the fence. There is that. Oh, let's see. Thank you. Oh, Enrique, thank you. Come again. You're welcome, comment. Hi, Breach. Oh, Matthew, yeah, thank you for bringing that up. Matthew says, do you have these live question streams scheduled? How often do you do them? They are really nice and informative. Thank you, Matthew. I just started last week. I think I'd explained, I have some awesome colleagues that do it in the evenings. And sometimes I join one of them. I join Jonathan periodically. I have a hard time staying up that late. Or if I am, I'm usually watching TV with my 81-year-old mom who lives with us. Or I'm hanging out with my husband on the days he's home from Harrisburg. So it's not really a great time for me, but on occasion, I do love doing them. It's fun. I like to see Jonathan, and it's just good getting some back and forth and two different viewpoints. A lot of times we merge. Sometimes we have slightly different, views on things. And because I had a problem with the night times, but people were saying, do a Q&A, do a live. I go, how about a lunchtime? Because I'm on top of my game between, say, I don't know, 6 or 7 in the morning until, probably 6 at night. So that I could do. So it's hard to keep my engine going until 10:30. Not when I want to be thinking, right? So yeah, so every Wednesday, 1 p.m. Eastern Standard Time, right here. That's my plan. As long as it's well taken, I'll do it. There might be some interruptions to schedule because if I have those are one of my hearing dates and hearing times. But I have a big thing about trying to win on initial and recon, so I try to keep those hearings to a minimum. And that's my goal: winning faster for my clients versus dragging them out and them being stuck with me for 3 years, if we can help it. Obviously, there's a lot of times when you can't do anything about it. You just got to go to hearing. But there is that. Thank you, Deb. Yep, Wednesday, 1 p.m. Eastern Standard Time, guys. Virginia. Thank you, Virginia. I've seen you a couple times. Well, that's very nice of you to say. Thank you for the kind words. Thank you, Christina. You guys are the best. All right, breach. I was approved for SSDI and SSI in November. Got first SSDI this month. Still no back pay. SSI and non-medical review. Okay, so they know you're disabled and you're going to be getting, and you're starting to get the SSDI. That's the easy part. The irony is that they actually did it before the SSI, which is smart because the SSI is going to be stopped. It sounds like your SSD is too much for SSI. So they already know the SSI is going to be stopped the month you're due SSDI. So they let you get the SSDI because they know what the prospective amounts are going to be. But because they haven't done the SSI yet, and they're slow on the financials, they don't know what your back benefits for SSI are going to be. And that is what they're going to have to take out from your back SSDI. So that's all. They'll figure it out in the wash. But I'm glad to see they gave you your SSDI early. Historically, they would make all of it wait until the SSDI is done, then they shove it off to the SSD people. So this is interesting, and I don't think I read anything about a change in procedure, but that doesn't mean I see everything. That's very cool that they started your SSD, even though the SSI hasn't run through, because usually that comes first, and it was very annoying. So that's very nice to see. So yeah, just got to be patient, unfortunately. But unlike many people, you're getting your SSDI now and not waiting. Because I'd see people wait 4 months, And yeah, I mean, you're at month 2. That's getting lengthy too. But anyway, hopefully it'll happen soon for you there, Breach. Michelle M. Fought cancer last year after radiation. I am sorry that you went through that. I went back to work, but was only offered 8 hours a week. I have scoliosis, 85 and 75% MRI a few weeks ago. Bad. I have to get off unemployment before applying for disability, right? I want to say no. But there is a little difficulty. Generally, I'd say no. I don't study state rules on unemployment. I only know the federal. So, but the thing about unemployment and SSD, they are not inconsistent legally. However, for unemployment, by and large, we have to attest to the fact that we are able and willing to work. Now those are general terms: able and willing to work, and of course, looking for work. SSD, we're saying something a little differently. I am unable to work full time. I'm not doing work activity earning me over SGA. So there are two different things. One is I'm unable to work full time. The other one just says I'm willing and able to work. So the Social Security Administration is not supposed to do anything about that at this point. They're supposed to just make the medical decision. If you go to a hearing, oftentimes, but not always, an ALJ will say, well, I noticed that when you applied for SSD, you said you were disabled since, January of 2022, but I see that you collected unemployment from January to March or June or whatever of that year. So isn't that a little consistent? You're saying you're willing and able to work, and then you claim to not have been able to work. There are so many there's so many proper responses to that exist almost 100% of the time. One of them is you didn't file for the SSD until after the unemployment was over, and when you realize, damn, I really have been disabled since January. We were in such denial a lot of times when we first stopped working. A lot of people hesitate and don't apply because they think they're going to get better, or they're like, I can't do my job, but I can look for another job. Little do they know they really can't do the other job either. So they apply for unemployment because that's consistent. I lost my job. I can't do that one, but I can do other ones. So I'm willing and able to work. Then it turns out they were dead wrong. So it's not always inconsistent. But I've seen a judge put people on the spot. So unless they're kind of prepped about this, they get all stuttery, like they feel like they're being accused of committing fraud, and they're not. So I wouldn't let that be a worry. There is a possibility one day in the future, I heard about this for a long time, and I don't really have a problem with it, that if we get unemployment and then we later get SSD for those same months, that it's going to offset, like you can't get the double. That's not the case right now. Right now, you keep the unemployment you got, you don't have to pay it back, and you get the SSD. That might change. That actually might be a valid change if they have to really tighten things up, because you are getting major double, sometimes more than you ever made working. So I could see saying, yeah, like, you can have them both during the pendency of your claim, but if you prevail on SSD, we got to take account for the fact that you got unemployment when you were actually disabled, it turns out now, and therefore unemployment wouldn't have been available had unemployment known you were disabled. But nobody knew, not even you. You thought you could muster it up. So I think there is something about that. Okay. And people will hate it. They're always going to hate when there's less money going in their pocket. But that is a sound rationale, I think, for if they're going to do that. I mean, it's nice that they don't. We lawyers don't want them to do it because it's going to reduce our fees. So, but from a policy perspective and the future of the SSA funds and all that, I get it. And I wouldn't be fighting it just because I want to have my pocket padded better as a lawyer doing the practice. I'm not saying you guys have to do that. Okay, Godiva. So Godiva's talking about when you have an old bachelor's degree. Well, let me just read it. On my psych records, it shows BS degree, which is false. And I think we talked about that. I worked 27 years in property management. I do have a cosmetologist license, but I've not used it in 20 years. How do I remove the BS degree in my medical records? That, again, you have to speak to your doctors about. SSA is not going to get involved in your battles with your medical doctors to properly record your medical history. But in terms of not having used your cosmetologist license in 20 years, that shouldn't be a problem. Old educational endeavors don't hold a lot of water. They don't really prevent us from proving what we can't do from physical or mental stuff, because that's all going to be based on the current medical evidence. And it is pretty well established that old education is moot far sooner than 20 years. So I wouldn't worry about it. When you put down on one of the forms that when they ask about any special training and you put cosmetologist, because it asks you and it doesn't give a time limit, it'll ask you for what year you got it. And then it's going to be clear that it's Stone Age, right? Okay. Now, if you are still a cosmetologist, different, because now you have learned work skills with that are in the 5-year range. But if you haven't, you're totally fine. Michelle M., I don't know what becomes your start date for disability. Do I have to scroll up? Oh. I don't even know what you're asking. What's your start date, Michelle? Start date, meaning alleged onset date, really depends on a bunch of factors. First, you have to be working under SGA, or since then, or anytime you were working over SGA, it could be argued to fail. There's a few different things we have to look at. You do want it to go back as far as possible, as far as reasonably possible. As long as there's a legal and factual basis for asserting it, we go back as far as we can, because if you don't ask for it, you're not going to get it. you'll get something wherever you ask or forward. So you kind of have to, give them all the opportunity to get you as far back as reasonably possible, depending on your condition. And of course, the fact that you're not earning SGA or it wasn't a failed work attempt. Okay. Oh, Breach, you're in Lancaster. Huh. Very nice. I am in Monroe County, Stroudsburg right now. I also go back and forth between Perry County. John, you're so funny. I can't post that up there. You're very sweet. Yeah, the bike's still there. Can you notice I haven't ridden it? It's a little cold up here. So Breach is talking about, he was approved November 2nd, he was approved November 2nd. The conditions were mental and neuropathy. The grid helped me. SSA never really mentioned my medical conditions. I assume you prevailed without the need for an ALJ hearing, Breach, or was it after a hearing? You said the SSA, not the ALJ, so I'm thinking it's down yonder, like, the lower levels. If you had unskilled work or hadn't worked in the last 5 years, the mental may not have changed your case at all because it just meant you would have been unskilled. And if you're already unskilled under the rules, it's really not a big deal. Now, it isn't a big deal for practical considerations. You said never really mention my mental conditions. What do you mean by that? Did they kind of mention it, but not really? I don't know what that means. Or do you mean they flat out just said, and by the way, in the awards, they don't really, in the explanation letter, yeah, they don't really tell you which ones. So did you get your DDE maybe? How'd you figure it out? Inquiring minds want to know. Hi, Angie. Well, if you already have one, they're probably going to do right by you. So keep positive about that. All right. Andrew, you said I tried, I got the no-go email. I don't know what that is. Oh, you mean, did you get a message about, you didn't, all right, I'm not sure what you're talking about. Let's see. Butterfinger. Those are yummy. Is it strange for Social Security to schedule both a comprehensive and mental health exam? By comprehensive, do you mean a physical? It's not unusual at all. If you have both physical and mental health allegations, or they see something in the medical records to suggest you do have perhaps impairments in both, then they will, if they don't find that your physical records are strong enough to award, but suggest there's a problem that should be delved into, and the same for the mental health, they're going to schedule them generally, unless they screw up. Joshua. Lost Medicaid when I turned 18, was homeless. Ugh, that's terrible. Therefore, unable to hold an address. I will just try to go online later today and see if I can get a state ID mailed. I have my birth. Are you still homeless? Or are you, you're on a computer. Are you at the library? I have my birth certificate and SS card. All right, you're going to have no problem. You're going to have to show up to get a photo on your state ID. So you're going to have to make arrangements to get there. But you're going to have to do that to get to medical doctors to build your case anyway. So, you have to keep those bridges alive between family and friends and new friends if you don't have old ones. And also, maybe speak to your, did you apply for Medicaid as an adult? And speak to your local welfare office that usually does the medical assistance work also, whatever your closest one is. Usually it's in a countywide. You know, I would go there. That's all kind of local stuff. It's not federal, but you can get it. And you know, they have caseworkers, I think, that might help too. So fingers crossed for you, Joshua. You can do this. I think you can. Common is saying, and I think he's referring to the Social Security earnings statements, the ones that I just discussed. They stopped mailing. I should have prefaced it with, comment, you said you've still gotten them in recent years. It is age related. Once we start approaching, I'm going to say it might even be, I haven't gotten one yet, and I'm 50. I turned 57. I'm guessing I'm not going to get one till 60. I hope they send them by 60, because you know, that's 2 years away from someone that could file when they're 62, which I'm hoping and praying I don't need to do that. I want to just keep working till I am 70. That's my goal. Big Muff, are CDRs less common after 55? I would say no. You're going to have a CDR diary. Could it change? Yes. Like, let's say they give you or it could be that's just like an overgloss review and they bypass it, but everyone's going to get a CDR even if they're 55, a CDR diary date. You might not even know that it bypasses, and they did some little thing in the background and said, don't think he's going to improve, you know, and they try to prioritize so the resources are not being spent on people who they don't think are going to improve enough to work. And part of that is an age-related thing. You jumped from 50s to 55. Now you have an age-related thing, so that it's not even if you won because let's say grid-wise, because you could only do sedentary and the grids applied because you met the other criteria, and you were, say, 53, and now you turn 55, and now you're going to have a diary date come up for a CDR. They have to prove now that you not only can't do the sedentary that you, or could do sedentary that they before said you couldn't do, they have to prove that you can do even more than that and do light. So failing on a CDR after 55, I think is rare. You know, someone really has to improve. And again, there are those impairments that are prone to improvement. Chronic degeneration might not be one of them. So in musculoskeletal, you know, one of the hardest cases to win on, but once you do, and if you're up in these ages we're talking about, like you and I are, I think it's, but you have to, if you stop going to all treatment, because then the sign is you did improve and you are one of those rare cases. So that's why you always want to have your ducks in a row. And I think everyone should stay on top of it. Maybe not to the same seemingly excessive degree of treatment before they prevailed, but certainly there's a level to which you should be, even after you prevail. Hi, Big One. Thank you, Big One. Thanks, Deb. Matthew, we are not allowed to say those things. What is your percentage rate of winning cases overall? We are forbidden as lawyers. So when you see a percentage rate from someone, it is probably a non-lawyer outfit who's allowed to spout anything. And there is no accountability, by the way. We are not allowed to. We're not allowed to do it for legal matters, because as the ethics bar says, the state bars, along the lines of, because the percentage rate doesn't even talk about that person. It doesn't ever talk if that person's going to be in that 99% or that 1% or whatever the percentage rate is. I will say this, though. There is a huge difference between practitioners and how they practice and what the results are. And I will say also, practitioners that only take, over 50, over 55 cases will have or should have an extremely high prevail rate if they're doing their jobs. And if those that take the more difficult cases because they recognize that those people deserve help too, even if you can't fill your coffers with them or else you'll starve and go out of business, you got to expect some losses in there. But I will say this, the people that get really anal about their work don't have those, like the young people that maybe lose 90% of the time. They don't have those poor rates for the young people. They may not have the, 95 and up rate either, though, because it's a whole different category. And by definition, they're not going to be that many wins. So I appreciate my colleagues who do take the younger cases as I do, because there's going to be some pro bonos that don't win and some that do win, but you're not going to get an award for them. You're not going to get a fee, because if you know how the fees work, sometimes that just happens. So, but yeah, we're not allowed to discuss. So I know that makes it really difficult, right? So someone would say, I got a super high rate, like I tend to say, but it's only because I know it's true. But I've also been in this, I've been a veteran, not a military veteran, guys. I should say a seasoned person in this practice since the get-go, and started when there was nobody really in it to speak of. There was a few really stellar people that wrote some books and stuff, though. And that's how most of us learned, and then with hands-on experience and sticking with it and making it an exclusive practice instead of making it the redheaded stepchild attached to a personal injury practice or workers' comp, or some do medical malpractice and stick it on, other areas of injury and liability sometimes tack it on, because they're figuring, I made 100 on that, maybe I'll make 1,000 on that. Like, it's just like the redheaded stepchild, and it's not given the same attention and devotion. So, obviously they're not going to have the same, the same rates as someone who, the many of us who exclusively practice it. Okay. Let's see. All right, Margaret, I can't understand what that is about. Yeah, sorry. Only because I'm not going to be able to explain that. But it does sound like you prevailed, right? Oh, you're finding it unacceptable that you didn't get the full back pay. They didn't find you disabled as far back as you wanted, or they're not. You filed in January 2020. They didn't agree that you were disabled back in 19. They didn't find that your evidence proved it. Okay, so you might have been disabled, but if you didn't have the evidence at the time that was needed to meet the laws that applied to that age frame at that time, it's the way the ball bounces. I mean, you can find it unacceptable, then appeal it. I think there's risks to that, but that's your right. So have a go at it if that's the way you feel. Virginia, I don't know if there's a question here, but I'll throw it out there. Waiting time, more or less, on reviewing on my expedited case after seeing a judge December 23rd. Yeah, if you saw, I had to go all the way to judge, huh? Expedited reinstatement case. I guess the lower levels found that you were not still disabled. My fingers are crossed for you, Virginia. Michelle. Okay, here's Michelle again. Again, 58 years old, worked all my life. One more question. How much treatment do I need I applied for, was it disc facet arthrosis, moderately to marked foraminal narrowing, spondylosis, DDD. Oh, did you mean spondylolisthesis? Spondylolisthesis. So spondylosis, and then there's also spondylolisthesis, which I think the latter is probably worse. It's that your cancer doc has something or other. Cancer doc has, she continues on, has me on bone depleting meds. Rheumatologist has me on meds to build bone, and to build. Would SSD want to see an ortho also? They don't want you to see anybody. They don't really care. It's your job to prove your case. I would have assumed you were seeing an orthopedist for all these diagnoses and that you're still treating for them, right? I would. If I'm saying that I have an orthopedic problem, I'd be seeing an orthopedist for sure. Okay. And doing all the therapies suggested, unless there's a very, very strong reason not to. Hi, Angie. Yeah, I'm sorry. That probably means that we're full in the category that you're, probably means you're in a category that we are full in. And, sometimes those will put out say that there's, waiting lists of sorts, but you can't wait for a waiting list. You got to keep looking for someone who will take your case that has an opening in that area. That might mean you're a younger person, which we are consistently filled. So when one goes out, another one can come in. It's tough. It's a tough age. And it also kind of depends on the impairments. My colleagues and myself included have to be very stringent on what we see in the case, and if there's a path to a win at that age, or if someone is, about to be bumping into a new age, so that could be what it was. But don't stop trying. There are others, and then just get all the information you can. And the biggest thing is treat for those impairments that limit you, even if they're not the one that took you out of your most recent job. All right. Because you're going to be building it. And eventually you're going to find the representative that has an opening. And it's going to take off, but you want to have your goods so you don't have to start it then. Right. Keep trying, girl. Okay. Just want to fly. Yeah, me too. I always wanted to do that. How long? Once being reviewed by the SSDI doctors, that would be the consultative examiners, does it take to make decision on my case? Also, if I get a prosthetic, does that mean I'm not disabled, although my other leg is still broken and surgery? Two different questions here. The determination after you go to a CE can vary. It depends on if all the medical records are in. Usually they are before they get the CE exam done, but not necessarily. Then everything's got to go to the medical doctor, the internal guy or gal with the SSA to look at all that stuff and say, okay, he or she's got this RFC of this. And then the adjudicator can look at that and say, oh, and our rules say that when there's a 45-year-old with an RFC of this, the answer is this. So it's kind of like checkbox. It can be, usually historically, until these really bad short staff times and poorly run nature of things at the SSA right now, it would be 2-3 weeks tops. Now I can't really say that because of all these people going on vacation or resigning, or you just don't know. All the people have to do their job. They're not going to skip over somebody like the guy that does the RFC just because he's on vacation. You're going to wait. The prosthetics don't always mean that limb is not severely limited, but they can. If the whole point was you couldn't walk because you never prosthetic and now you have one, that can make a difference. Obviously, you still have another leg that is still broken and needing surgery. So it would sound to me that they would find that you're disabled at the moment, with or without the prosthetic, but you might have a durational problem. And I shouldn't say problem. It's like it's a temporary problem. I also know people with prosthetics, and I've had my handful of amputees where the prosthetic, particularly if it's lower extremity, takes quite a bit to get it where they are comfortable, not getting infections, not getting a lot of rubbing and pain. And some people with amputations have like a CRPS and still feel phantom pain. And so there can be a lot of other impairments beyond just the fact that a limb is missing and a prosthetic has replaced it, which makes it much better, but not always in a way that's going to let the person be able to do what they were stopped from doing because of the impairment. So, you know, treatments, including prosthetics, don't always get the person to where they need to be. And again, all these things are impacted by your vocational profile. It is. You could be 55 and this could fly, and you could be 45 and it's not going to fly because of the rule that you don't get to use at 45 that you get to use at 55. Okay. Okay. Oh, Virginia, you're really sweet. That's because of the filters. Gotta love the filters. So I must admit, it's the filters. Okay. Hi, Love T. Hello. What does it mean when your benefits is at the process payment center? Does it mean already been approved? Oh, baby, I think so. It should. Payment Processing Center, PC. So wait, but you'd think you would have gotten a letter or notice already, but not necessarily. Things sometimes are a little backwards, but that sounds very promising. They don't send us there unless we're getting some money. Okay. Just want to fly. I keep having that song run through my head because of your screen name, your handle. 54-year hubby has stage 4 cancer. Oh, I'm very sorry to hear that. I'm sorry. He and my 14-year-old stepdaughter now getting SSDI. Can spouse get something for taking care of him? I just did a video on child in care. A child in care. So you could, it would be through your husband's work record to get a child in care benefit because you don't have to be disabled yourself. And the child is under 16. I would contact them immediately. And the reason why I hesitated is because your husband's getting 100%, your 14-year-old's getting 50% on top of his 100%. So let's say his 100% was $2,000. The child's getting $1,000. $3,000 is coming into the household. That's 150% of your husband's benefit rate. Depending on what his family max is, which is a whole mathematical calculation that depends on his own benefit rate, which depends on his income earned in his lifetime. There could be extra for you. So, like for instance, let's say the family max is 180%. Your child's only getting 50%. There's a missing 30%. I would contact them like yesterday. And if you're at home now, if you're out working full time, that's not going to work because you're not caring for that 14-year-old day in and day out. But if you are not working, and there's a limit, so you could be working a little bit and still be eligible. So you're going to look up the work earnings limit, ask them about it. But if you're not working, or if you're working very minimally, goodness gracious, it's my husband. It's like a jalopy with the sound, the tune that comes in when he texts me, old jalopy. Yeah, you want to check that out, and it'll depend again if you're not working or if you're working only a little bit. If you're working full time, making a robust income, you're probably not going to be able to get that. But call them, find out for sure. Oh, thank you, big one. Yeah, it's kind of fun doing the live streams. Okay. I've heard, this is Matthew, I've heard it's easier for people to get approved if they have the same exact situation, same age and disabilities, if they are applying for SSDI, if they 40 were credit, if they have their 40 credits, I think he's saying, and his and the recency credits compared to SSI. I'm going to say, if you're talking about the disability determination itself, I'm going to say that's not true. It's not supposed to be true. And I haven't really seen it. If it was easier for them to, with the same exact evidence, to prove they're disabled versus an SSI person, there would be such a civil rights action. Holy moly. They can't discriminate that way. The rules are exactly the same between the two of how to evaluate the medical evidence and the rules of what is disabled and what's not. So I don't think that's true. I would not accuse the SSA of doing that at all. I really wouldn't. But it's a good question. Thank you, Godiva. Matthew asks, can I apply for SSI as well as SSD? I plan on applying for it if my SSD would be $14.50 per month. No point, because, well, you're not going to get SSI with SSD if you're bringing in SSD of $14.50 a month. However, if you have that, if you have no other income or it's very low, you could get SSI for those. If you are poor already, you could, when you're not getting SSD, you could get SSI for those 5 months of the waiting period. And that could be almost $1,000 a month for 5 months. You could be getting another $5,000 just to put aside, do whatever you need to do with it, because you're not getting SSDI for those months. So that SSDI isn't going to boot it out for those months. And that is why I always suggest a concurrent claim, guys. If you are poor or you think you're going to be poor in the next few months, having spent down everything, I would do it. Why not take that extra $5,000 from SSI? It's going to stop, as per the month you get the SSD, but it's still extra money on the table that you could be collecting. So I would, and there's many people that won't apply to. You have a working spouse, you have a 401k, but for those that don't, and there's plenty, I would say for sure. Big Muff. Yeah. So you don't feel like you can even step down treatment after you won? Is that it? Because you've really got a lot of issues going on. I get it. Prayers to you, pal. Hang in there. Fight the fight. Angie, does an attorney help at recon level, or do you think the most impact at the hearing? That will depend on the attorney or non-attorney rep that you use. Some don't do things on initial and a recon. They just make their client do it, which I think is by design. I don't approve. And some do. So if they're not going to do, you could ask them, so what services do you offer on recon besides officially being my representative, which means if you win on recon, they get paid. If they say we work, we help you draft up your function report. We are the go-between with any questions the DDS asks and needs to know. We don't have you do it, we do it. They might say we order records that we see the SSA had trouble following our instructions on getting them. We make sure those have been requested. There's so much things that can be done, including we also start putting together your brief to get it so it is top-notch and ready to go way before the hearing, which means that it can also potentially be used when the shoe fits for an on-the-record request for an award. Those are not very common. I don't do them. I do briefs on all my cases, but I don't always make it an on-the-record request because it's not appropriate. That I know because I know how the ALJs general, rules have to be. that they're not going to award certain things on the record. It's just easy to know. I will do it if I think there's an avenue for that, particularly if I, think they should. But I will say, we did just have a recent one, which was beautiful. But there was a long spell when they didn't really do it. At one point several years ago, they were kind of doing them, and then they kind of stopped. And I don't know what the policy goes on behind the scenes, because those are not official policies, I don't think. But, but for that reason, it's nice to have a brief that is so got all the nuts and bolts in there as you go along, and then you're just feeding in the last details. You already have your theory of the case. It makes for being able to get it in well in advance, instead of getting it in 5 business days before the hearing, which is the last date you can. If you get it in a month or two beforehand, the judge, I think it's a greater possibility that they're going to potentially look at it. And even if you didn't ask for an OTR, they might consider doing one if the case is right. I mean, again, if it's right, it's a very case specific thing. All right, guys, I think we are getting to the end here. It's been, almost 3 hours. Matthew, I heard that some people that get approved for SSI or SSDI can move to a different country afterwards and still receive benefits. Is this true or false? It is generally not true for SSI. That's a welfare program paid for by the taxpayers every day they work. So, and not having been earned by the recipients. So I think the theory is, don't really want to give them the charity that they can go spend in another country, right? Where there's no oversight. SSDI, yeah, for the most part, you can move to a different country. There's certain countries you can't move to because perhaps they're not our allies. Perhaps we don't trust them to be not doing wrong things to you and your monies over there. Not sure. But yeah, a lot of people move to a more affordable place, for instance. A lot. I have a client right now in Panama. All right. I think we should call it a day. What do you guys think? Oh, shoot. If I can catch up with questions. Yeah. So Matthew, your advocate doesn't have bar rules because he's not a lawyer. So he doesn't have the higher ethical requirements that we have. So no, we can't give a percentage rate. We can tout our horn and all that business, but a percentage rate, I think and I will say that I've seen worse than 80%. I've seen people brag about numbers that are worse than 80%. So I don't think 80% is horrible. I probably wouldn't survive on it, but I think that's okay. But no, yeah, we can't. And the funny thing is, I think that the groups that might have the rumor is the groups that have the lower rates, they're usually extremely volume based. So some of them may take every case that'll walk through the door, make sure they're filed, sit back, and hope for the organic wins. If 50% win organically because the person would have won anyway, bingo, you're a billionaire. While 50% of your clients lost and are eating dirt. So that's where it becomes an ethical thing for me. To lose a case is a big deal around here. Let's put it that way. Angela, hi. I have multi-level DDD, degenerative disc disease. I had RC surgery, rotator cuff, I believe she's saying. MRI shows arthritis in my lower lumbar. I'm 61 years, applied in June 22. Oh boy. What does your lawyer say about this, Angela? That's really long. Something's stuck. If you don't have a lawyer and you want me to learn more details, let me know. That's appalling. We have bad weights, but I haven't seen that bad. So I feel like something's stuck. Anyway, if you want to reach out, but just refer to this and let me know, because I get a lot of emails. So I would want to be able to refresh. Okay. Okay, Virginia. I think we're going to call it a day very soon, guys. Virginia, I've been going to the doctor straight since 2013 and have proof of a lot of medical records. How far back can they go? I'm fine with going back when I applied. They're not going to really want to go back more than a year or two before you applied. I survived by DJing since. Okay. That said, sometimes older records are helpful. It's not, they can't go back that far. You're never going to be paid if it's SSD for any time before May of 21, it would look like from your numbers. But they can, if you can prove it, depends when depends when you said you were disabled. If you said you were disabled since 13, then that's your alleged onset date. They could find you were disabled at 2013 if your records rose to that level and whatever age you were at a time. They're just not going to pay you all the way back. But your Medicare would be due tomorrow if you prevailed. So there are benefits, not to mention that all the years after 2013, if you win on 2013, will not count if there are zeros, or in any way if they're going to bring down your otherwise Social Security benefit amount. So you kind of get those disabled months to not drag you down. Now, in this case, you were working, so maybe you were dragging yourself up. I don't know. It depends what your prior income was, but you can always go up. You can't go down due to the work after your disability in terms of affecting your benefit rate. Okay. All right. Matthew, I talked about is 80% good. I probably did it after you posted this. I don't think it's horrible, particularly for an advocate. I can't say more. I would say I prefer to be. See, you see how our hands are tied? That's 4 out of 5 win, 1 out of 5 do not. But I will say this: if your advocate takes very difficult cases that are younger and is willing to accept the loss because he tried, and like maybe he brings what would be a 10% of those people win, he brings it up to 50%. God bless him. That 80% is not, doesn't tell that story. So 80%, even it's not bad regardless, because I know lawyers that do worse than that, because they're just not doing. They're not doing. But if he's taken the younger people, God bless him. We need more people that are her. We need more people like that are willing to take the hit, because they know they're going to have a very strong rate with everybody else because they put in the work. And that's how you can afford to do that. That's the only way. So unless you're going to take a million cases that nobody can work on because there's too many, and then you try to do that organic, selfish win of 50% so that you can be a millionaire without working, and 50% of your people are in the dirt, I mentioned before, right? So, it could be a very good rate given what your guys is doing. Maybe 50% of his cases are under 50. I will tell you, I don't take 50% of my cases under 50. I take under 50s, but it's a lot less than that because it has to be to accomplish what we need to accomplish. But, maybe he does. So, and I would say God bless him majorly for that. It was so funny because I thought about hiring somebody that only did that. I'm like, if someone could come in and take 50 cases at a time or 100 cases at a time that are under 50, they're not going to have, presumably, a 95% win rate. But if they have something that's better than if those people had nobody, then it's a good thing. And if it pays that person's salary, it doesn't have to give anything to me. I do my own work, but how great would that be? They'll need the salary, and they're probably going to need someone to take it to hearing if it has to go to hearing, which probably will. But if they can work up the case and make it all super perfect, I don't know. It's an idea. It's just a little scary. But anywho, I think we're good, right, guys? I know they keep coming in, so I know I'm screwing myself by scrolling down. I'm going to answer Ellie Noir here. Received letter from SSD. My case is under non-medical review. Do SSD check bank accounts and 401ks? They have some sort of, I think, finger that can touch certain things, whether it's right now or they go on your word with that or later, because they do find out when people have earnings coming in, sometimes. So, but with SSD, it's not like SSI where they give a hoot what you have in your bank account. It's irrelevant. They just need to know whether you're working. So for SSD, that wouldn't be the issue. Okay, that would be if you're SSI. All right. The non-medical review would be some other things like, do you have federal debt? This is if they prevailed. You didn't say whether you prevailed or not because they sent you to non-medical review. Apparently, regardless, it's asinine. But yeah, they're going to check to see if you have federal debts, if any arrears in alimony, child support, federal debts, and then they might offset those if you have back benefits. But again, that's only if you prevailed. I don't know why they would do a non-medical review if you didn't, but apparently they're telling people they are. So unfortunately, sorry, Ellie. Or L. Is it L? Sorry if I misspoke that. You're welcome, Virginia. Oh, Matthew, I don't think there's really a way for you to self-estimate your residual functional capacity. It's you're so subjective because it's your body. You might actually accurately know what your RFC is, but it's what your records say it is that counts. So yeah, it's hard. I'm sorry, but you can try. Give it a try. All right. I think, guys, I don't think I left anybody out, right? If it is, it's someone who just popped in recently, and that's the problem with coming late, right? Thanks, big one. Appreciate it. From Texas. Yeah. Yeah, I think we're good, right, guys? All right, so next Wednesday, I'm going to aim for the same, 1 o'clock p.m. Eastern Standard Time. Otherwise, you got the 9 o'clock video shares coming out from whatever's floating around the office on any given day, and anything to assist. Or if you send up any questions that you think would be a good video on, definitely feel free to do that, and I will do my best to get it out to you, okay? Aside from that, I got to get ready for my 5 o'clock Zoom with the peeps, the colleague peeps. I will talk to you guys later. Thanks again. I'll talk to you.